Okay. Good morning. This is Renee Line, Chair of the Colorado Real Estate Commission. Today is October 7th, 2025, and it is 9 a.m. This is the public meeting of the Colorado Real Estate Commission. We will now call this meeting to order. We can start with having the director call roll.
Renee Lines.
Here.
Autumn Rubal.
Here.
Erica Doyle.
Here.
Erica Sanders.
Here.
Bernadette Bergeron. She's having technical issues, so hopefully she will join us shortly, but so far you have a quorum.
Okay, David.
Excellent. Thank you very much, commissioners. Members of the public, I am launching a poll at the current time for those of you that are interested in seeking continuing education credit for attendance at this meeting. So if you are, please complete that poll. If you are not seeking continuing education credit, there's no need for you to do so. You don't need to complete that poll. It is not a mandatory thing. I will leave that up for a few moments here. If anyone does encounter any technical issues, please feel free to reach out to me directly at David, that's D-A-V-I-D, Donnelly, D-O-N-N-E-L-L-Y, at state.co.us. And we can include you in the certificates, which will be sent out in a couple days following the completion of today's meeting. So with that, commissioners, I will pass the camera back to you, and you can proceed. And I'll have the poll disappear from your screens momentarily. Thank you.
Okay, thanks, David. All right, so we'll move on to the approval of the meeting minutes from last meeting. Can I have a motion to approve the board meeting minutes from August 5th, 2025?
Motion to approve. Second.
Any discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes. All right, and then we need public presentation of any issues that are not on today's meeting agenda. Is there anyone, David, that's...
Thank you, commissioners. There are a few hands that have already popped up here. So while we call on some of those individuals, if there are any other individuals from the public that would like to address the commission today, please understand that the citizen participation period is not to address specific investigatory matters that are on the agenda for the day, but that but any individuals may utilize the raise hand icon in the Zoom platform to raise their hands. And while that comes about, I'm going to unmute the first individual that has raised their hand, and that's Ray. Ray, I've asked you to unmute, so you should be able to unmute and address the board, and I will, and you have 3 minutes.
Good morning, commissioners. I'm also a certified general appraiser, and in the last month or so, I've had a few brokers and appraisers, my brothers and sisters in both industries, have stated that in the MLS is across the state, a lot of brokers are putting what the commissions are, or fees, or whatever you want to call that, in the concessions. So my suggestion might be to investigate a little bit about doing a CP commission position about excluding commissions from the concessions. They are not concessions, and that down the line will hurt us as an industry. That's just my opinion. And at the Rocky Mountain Appraiser Association meeting, there was like 5 or 6 people that we got into a discussion about that last night at our bi-monthly meeting. So I just wanted to bring it to your attention. Thank you.
Thank you, Ray. Next, Mr. Tyrone Adams. I have ask you to unmute, and I will reset the timer here, and please feel free to address the board, or excuse me, the commission.
Good morning, and thank you, commissioners. I'm Tyrone Adams. I'm the CEO for the Colorado Association of Realtors. And I know you guys have a really busy schedule today, so I'll be brief. But I do want to address some communication I received last week regarding ex parte communications. So I'm just looking for a little bit of clarification. When I reached out to a couple of commissioners last week to discuss some of our members' concerns regarding specific rules and form modifications, I received from Division Director Mark Waters explaining that direct communication with an individual commissioner was inappropriate as it was considered ex parte. To the extent that my outreach was not appropriate, I do apologize to the director and also to the commissioners. I was not trying to put anybody in any compromised positions. But for the sake of clarity for CAR and other stakeholders for future reference, could you please confirm that such direct public stakeholder engagement with appointed commissioners regarding proposed changes to commissioner-approved forms and rules is in fact inappropriate ex parte communication? Thank you for your time and clarification on this rule.
Thank you, Mr. Adams. Excuse me.
So commissioners, David, before you go on, commissioners, no one can reach out to you directly to discuss items that are commission business that are on your agenda. That is considered ex parte communications. So when we engage in rulemaking, there is a stakeholder process. The way that we are going about it now is probably more inclusive than it has been previously. So if you decide to move forward with rulemaking after today, we will start the stakeholder engagement process. That is one way that parties can engage with the commission and also the division on different policy matters. There's also the actual rulemaking hearings themselves. And then there's the public comment portion of your public meetings. So that is how to communicate with the real estate commissioners. And if you have something that you want to have shared with them on one of their meeting agendas, you can always send it over to the division and we will consider it for putting it on the agenda. Thanks, David.
Thank you, Director Waters. Appreciate that. Kent Levine, I've asked you to unmute, and please feel free to address the commissioners.
Thank you, David. Good morning, commissioners. My name is Kent Levine. I've been working on the forms initially with the forms drafting committee in about 1975. The forms committee was formed in 1978. I was fortunate enough to be appointed a co-chairman, and then in about 5 years later, since there was no other co-chairman, I became the chairman of the Forms Committee, the Special Advisory Committee to the Colorado Real Estate Commission on Standard and Approved Forms. This year was a new process, and that's what I want to comment on. First off, I think Melissa did a superb job putting the drafts together. We did have through the full AFC two meetings with Melissa and provided some comments. We had not heard back any result, and that brings to the next point that we don't know what the final forms are yet. They have not been posted. The staff, because it's the form process has now been taken internally as opposed to external. Internally is very similar to what was being done from 1971 to prior to 1978. And it may very well be that Section 8.4 of the contract on metro districts was modified. I saw an earlier draft and it did not comport with the requirements today. I don't know if the change got made or not. Also, water rights. There's a concern every time we do the forms, we make certain or address, is this within the competency of the typical broker to be able to complete? If not, how is that going to be treated? And my time is very close to being up. I think I've hit the items and what the solution is. I don't know, other than if the forms committee, I know it's going to be, Marcia had indicated it's going to be much broader. So I'm out of time. I thank you so much.
Thank you, Kent. Appreciate your comments. Keith Alba, I have asked you to unmute, and you have 3 minutes to address the commission.
Yeah, good morning, Commissioners. I just wanted to be known that for some reason on the division's website this morning, the announcement and the ability to register for this meeting had been removed. Not sure if that was intentional or accident, but we may not have everybody that wishes to speak to you today the ability to do so because the ability to register for this meeting this morning had been removed from DORA's website.
Thank you for that information, Keith. Lori Miller, I've asked you to unmute and you can address the commission.
Thank you very much for allowing me to speak with you today. I'm Lori Miller, and I am the CEO of the Pikes Peak Multiple Listing Service. And the reason for why I wanted to speak with you today is we had a situation a couple of months ago where we had a listing in our MLS system that was input for a little over $700,000, and a price change was done on the listing and was brought in under it was around $350,000. This caused quite a stir. We received a lot of phone calls. When we talked with the listing agent, the seller had directed the listing agent to do the price change in the MLS that way. My concern is what I need to get from the commission is that it could be misleading to a consumer when a listing is put in at $750,000 and then is dropped to $350,000. And the reason that it was dropped so they could generate interest, but the seller had no intention of selling the listing for that amount. And as an MLS, we're concerned we understand that it is up to the seller what can be done with that listing, but we're concerned about what that might do to the consumer because that's misleading. And so I wanted to get some direction on from the commission how to handle that.
Thank you, Lori. If the commissioners have any questions or comments for any of these individuals, you can certainly address those. But if not, commissioners, that was the last of the available hands at the current time.
And I'll just clarify, so the individual did not have a listing agreement for the higher price, correct? They just put a higher price in the MLS and then reduced that price to make it seem like there was a large drop and it was not just an error. Is that what you're saying?
No, the listing agent had a listing agreement for $750,000. And so it was in the MLS at $750,000. And then what happened was had sat on the market for a little while. And so the seller had read what we were told when we addressed this with the employing broker. The seller had told the listing agent that they had read somewhere that to do a price change like this and it would generate interest. And so the seller approached the listing agent and the listing agent approached their employing broker. And unfortunately, and the employing broker said, well, this is, what your seller is directing you to do. And so an amend extend was done to reduce the price, which it did. And we received a lot of phone calls from agents regarding it. And so did the office where this listing existed. And shortly after that, the listing was put back at the original price that for the listing agreement. Unfortunately, what happens that our concern is that they were the seller was generating interest, but had no intention, which they also put in the amend extend, of selling it at the $350,000. And of course, with the listing going out and being disseminated out to multiple listing sites, it would lead the consumer to think that that property, which is really a $750,000 property, was available to them for $350,000. So, as an MLS, we were looking at this. Do we need to put a rule where, that can't be allowed? But, knowing that it's up to the individual, up to the seller, in regards to what they can do, we're just kind of looking to the commission to help us and how we should move forward with something like this.
Thank you so much for that.
Again, commissioners, no other additional hands at this time. So I will pass it back to you all for next items on the agenda.
I think that would be me.
All right.
Bear with me. Okay, well, we'll now take up hearing matter, case number RC 2023-0010, the Colorado Real Estate Commission as petitioner versus Justman, license ER 100031318 as respondent. Oral arguments are scheduled to be heard today on exceptions to the initial decision filed by both the petitioner and the respondent licensee. Present to assist the commission in reaching a final agency order are Melissa Phipps, Senior Advisor, and Sue Kim and Felice Haas as Assistant Attorney Generals, as
We like to say
Adjudicatory.
conflict.
Thank you. I adjudicatory counsel. Sorry about that. Staff, can you please check audio for participants?
I'm just going to let you know that I will be recusing myself due to possible actual or perceived conflicts from this matter.
I will also be recusing myself as I participated in the mediation.
Okay. Are we able to check audio for the other participants?
Mr. May, could you jump on real quick and test to see if we can hear you okay? I see that you are unmuted. Mr.
Madam
May?
Chair, this is Sue Kim, and good morning, Madam Vice Chair and Commissioners. I wonder at this point in time if we can delay or postpone the sound check until it's clear whether the commission wishes to enter into executive session either earlier or later. And then when you call the parties, a sound check at that time might be more useful. If that's
Okay.
okay.
Okay. Well, we'll continue on. The commission has had an opportunity to review the initial decision issued by the administrative law judge following a hearing. Exceptions to the initial decision have been filed by both the petitioner and the respondent. The commission has reviewed them and the parties' responses. The parties have been informed that oral arguments will proceed today after initial matters, public comment, and possibly executive session. When called, each party will have 10 minutes to present arguments. The commission will then deliberate on whether to adopt, modify, or otherwise act on the initial decision and proceed to a final agency order and final discipline, if any. We may table the case to take the matter under advisement if needed. At this time, I invite a motion to enter executive session to discuss legal questions, options, or issues with counsel, and to consider matters required by law to be kept confidential.
I'll second.
Okay. Is that a proper motion? Because I don't know
No.
in motion. We
Autumn,
need a
you
motion.
can make the motion,
Okay, I will make the motion to move to executive session. Thank you, Renee.
and I'll second.
Thank you.
And Madam Chair, if I can clarify that at 9:21, the commissioners have moved and seconded to enter into executive session pursuant to section 24-6-402 sub 3 sub a sub 2 of the Colorado Revised Statutes for the purpose of conferring with adjudicatory counsel and receiving advice on specific legal questions and issues related to this case, RC 2023-0010, Colorado Real Estate Commission versus Rachel Justman, ER 10003131. If that properly reflects your intention in the motion.
Yes. Let the minutes reflect the vote to enter executive session was unanimous.
Madam Chair, if I can,
Yes.
I think you've called the vote and a second, and sorry for going out of order, but to clarify the motion, I think at this point, if you don't mind actually calling for the vote, that will be a little bit clearer.
Oh, sorry. So we had a first, we have a second. All in favor?
Aye.
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 Opposed? Okay. Now let the minutes reflect the vote to enter executive session was unanimous. Commissioner Lind will not join us for executive session and recuses from discussion. Did I do that properly?
I think you're ready, Madam Vice Chair, if we can get some direction from staff on how this should work.
Commissioners, I believe that you have a executive session link that you can join. So if you can just simply mute here and turn your cameras off here, and you can join that meeting, and we will monitor on this end to ensure that everything is buttoned up on the public side of the meeting. Thank you.
Do we have all the commissioners back on? I see Autumn. Bernadette. Okay, as we resume and re-enter open session, I want to thank you to the parties for appearing today. For a number of reasons, the commissioners are unable to proceed with oral arguments. Staff will contact you with additional information and will schedule oral arguments for a later time. I would like to invite a motion to continue oral arguments for a later time and table the matter for the next available meeting.
I'll motion to table and push to the next available meeting.
Do we have a second? All in favor?
Aye.
Aye. So with none opposed, the matter will be tabled. And again, staff will be in contact with the parties to schedule for a later time. And at this time, Renee, you are back in charge.
And I will excuse myself at this time with my thanks to the commission. Thank you.
Thank you, Sue.
Sue.
Renee, you're on mute.
Thank you. Said, unfortunately, for those of you watching, we're going to go into executive session again. This is Commissioner Chair Renee Lind. This is a Colorado Real Estate Commission meeting being conducted October 7th, 2025. The time is now 10:06 a.m. And I move the commission enter into executive session pursuant to Colorado Revised Statute Section 24-6-402 3A2 for the following purpose: to confer with counsel to receive legal advice on specific legal questions regarding the following meeting agenda items. Policy Matter B, draft rules, client informed consent. Policy Matter C, proposed commission position 31, management of confidential client information by an employing broker. Policy Matter D, draft revisions to Rule 6.17, duty to disclose conflict of interest and license status. Policy Matter E, proposed revisions to Commission Position 22, conflicts of interest, and forms presented for non-rulemaking hearing. Okay, is there a second?
Second.
I'll second.
All right, all those in favor?
Aye.
Aye.
All right, we have 5 votes in favor. We will now enter executive session. So everyone mute and turn off their video to go into executive session.
Whoops.
What happened here?
Okay, is everyone back? Autumn, Erica Bernadette. Okay, looks like we're all back. So we're next going to move on to policy matters. And Director Waters is going to start with meeting dates.
So this one is easy, commissioners. You don't even have to vote on it. It's just putting you on notice that Doreen has put together the meeting dates for 2026, so you can mark those on your calendars.
Okay, thank you so much for an easy one. So before we start on the other items, I don't know about anybody else, but I have been losing so much sleep over all of these items. So before we go into the next things, I have some concerns I want to bring up. I wrote down some things. So we've been discussing and debating how to handle informed consent of confidential information since February of 2024. And we're still unsure how to do it. We may have acted too hastily in removing 6.3, but we don't know. This is a very important issue as it affects over 40,000 brokers, their families, and their offices, and everyone there. I'm one of those brokers, and I want to make sure this issue is addressed properly, as it could have a huge impact on the industry that we represent. But I'm not sure how to resolve the issues that have come up. As commissioners, we try our best to protect the public and also enable all the brokers to have the opportunity to do their best job when handling contracts and clients. So I understand the need to protect a client's confidential information. I understand the need to be able to seek guidance from the employing broker. I understand that some clients may not want to sign another document partway through a contract. So as a commission, we're trying to make sure that we're making the correct decisions. But after all this time, I'm not sure what the correct decision is. And I'm not comfortable changing the rules and forms without knowing what the original intent was by the legislature. So I have two motions for consideration. I move to table the removal of 5.3 from all the listing contracts and table the changes to the rules and the commission position statements until we receive clarification from the legislature. I move to direct division staff to get clarity on what the legislature meant when they drafted and approved the statutes that we are currently trying to interpret. The legislative session starts in January, and as part of the sunset review, I would like the legislature to give us a ruling on what is meant by the statutes, and also how to handle informed consent, Rule 6.3G, and Section 5.3 of all listing contracts. After we get this, after that occurs, the commission and the division will know how to proceed with the rules, contracts, and commission position statements, and we won't have to guess on the interpretation. So I have those two motions that I just moved for consideration. If anyone would like discussion.
So Renee, can we do like maybe one at a time? One motion?
Well, they kind of go together, but yes, we can do one at a time because we need direction from the legislature. But sure, we could, which one do you want to talk about?
Whichever motion you want to start with.
Well, I'd say the easier one, well, I don't know. It doesn't matter. But until we get a ruling from the legislature, I don't think we should remove 5.3. I think we should leave it alone. I don't think we should change the rules, the commission statements. I think we need the clarification. So that's why I said I moved to table the removal of 5.3. I think we can go ahead and look at the forms. We can go through and approve all the other changes to the forms so we can get everything corrected, but we leave the 5.3 in there until we hear from the legislature.
I agree with you on that. I agree with that. Let's table it till we get complete clarification from them.
Yeah, we have sunset review that we're in the process of, developing everything that they're going to, asking the legislature to review. And this is a perfect time that we can ask them to give us a ruling on the statutes and the informed consent, the 5.3, the 6.3G. They can give us the ruling on it. And with that clarification, we can move forward and we will know exactly how to do all these other things that we are trying to come up with for rules and position statements, et cetera. We won't have to be guessing as to, did they mean this? Did they mean this? Have we been doing it wrong? Have we not been doing it wrong? We can get the clarification we need, and we can have the legislature do it as part of the sunset review, which is perfect timing because the legislature meets in January.
I just have a question about that. So does anyone have any insight as to whether or not this will be included in sunset? Because for an example, when I had my interviews, I was told that it wasn't really part of that. So I don't know if I misunderstood. I don't know if that was accurate or what, but are we certain that this is going to be a part of that sunset review?
If we're making a motion and approving this motion that we are directing, division staff to get clarity from the legislature, then it should be part of the sunset review.
You do not get to dictate what is reviewed in the sunset review. It is a completely separate process. And you're asking a legislature that will convene in 2026 to opine on a law that was passed in 1994. So you guys have been hesitant about making any decisions on this, claiming that it was all too new, although this was an issue that came up in 2019 as a result of consumer complaints regarding how employing brokers were managing confidential information. And it resulted in the commission disciplining those employing brokers. It was a trend that we saw beyond 2019, which is why we proposed revising the rules, and we started working on those in 2023. We did stakeholder engagement. We even reached out to the largest trade association in the state for their input, and it was crickets about the change to 6.3G. It wasn't until the rulemaking hearing that suddenly there was an about face in that trade association's thoughts on the rule. You guys kind of abruptly just repealed 6.3G. And then we have been working through this at the commission's direction since then. We have sent out surveys to employing brokers. We took over drafting the forms and identified an issue because there's a conflict in the law with the language in 5.3G in the listing contract. You are a body charged with protecting consumers, and this is not consumer protective. So in August, you gave us further marching orders. You keep changing your minds, and it's not protecting the consumers. You don't get to drive what the sunset review covers, and that will be a separate issue when it is finally released next week. That the content of that is confidential until October 15. You don't get to dictate what goes into the sunset bill either. So respectfully, Madam Chair, if you want some sort of declaratory order on what the law requires, we can seek that through the courts, but I don't think you're going to get your answers through the legislature.
Okay, but the fact that this has been going on for years now, and no one knows how to fix this. We keep going round and round and trying to fix it, and there's always a problem and another problem. If we go back to the legislature and have them provide a ruling on this, then we can get clarity and then we can move on.
The Real Estate Commission has rulemaking authority. That's how you provide clarity, is through rulemaking. When there is an unknown in statute, it's your authority to be able to promulgate rules. You've failed to do so far.
We are dealing with so many people that this affects. We don't know what the right answer is because there's always another scenario, and it's going to affect so many people and this entire industry. It seems like, we don't know what the right thing is to do. We've been trying to figure this out, and we haven't figured it out yet, exactly what to do. So I don't understand what the problem is to go back and ask the legislature to give us a ruling. They are the ones that approve the statutes, et cetera. So why can't we go back to them and get a ruling? And then we won't have to guess and try and come up with this interpretation. They can tell us what it is.
Madam Chair, the legislature doesn't give a ruling. They promulgate the statutes, but they don't interpret, they don't go back to the statutes and they don't provide rulings. Sometimes court do. Would you like to have another executive session to discuss your motion?
No, I don't understand why we can't proceed and ask the legislature for clarity on this information. We have so many questions and we honestly don't know where to go with this. It's clear because we've been dealing with this for so long. I'm trying to come up with something that would give us the clarity. And if we could get the legislator to provide clarity on the statutes, et cetera, then maybe we would know exactly what to do with our rules and commission position statements.
But they won't. Courts usually do decide the meaning behind the statute when the case makes its way through litigation.
Okay, the legislature is the one that approved these statutes, and we're just trying to get, we have so many interpretations. So we could ask the legislature what is, they're the ones who approved it. What was meant by this? And then we don't have to guess and try and figure this out and create all these new things. I mean, we're still not addressing all the issues.
Madam Chair, court usually looks at the legislative history, and based on legislative history and the plain language of the statute, the court usually decides the meaning of the statutes. You creating some brand new legal process that is not familiar to me. Legislature, it's unorthodox to go back to legislature and asking them what did they mean.
Okay, but we're not getting anywhere with this. Why can't we create a bill to ask them to provide clarity? And then we would know for once and for all what to do with this.
If I may, I've only been part of this discussion for not since 2023 when it started. And I don't know if we're jumping the gun here because it seems like we're maybe a little out of order. But if we are we talking about specifically, because there's multiple issues on the table, are you talking right now about 5.3 in the contract? Are you talking about the rule?
I'm talking about not doing anything with the drafted rules and commission position statements until we get a ruling from the legislature. I'm talking about leaving 5.3 in the contract until we get that ruling. So that's why I said I moved to table the removal of 5.3 and all the changes until we get this clarification. I don't know how we can move forward without this clarification. And if we
I may have a differing opinion because I do think that we can make a decision on 5.3 based on the information that we have, which, I mean, I don't know if it's appropriate to just discuss it at this point, but bottom line, like, it's 5.3 in the listing contracts has generated a lot of conversation for good reason. But what we have come to understand is that it is giving a blanket disclosure, right, of consent, which, based on the current statute, doesn't seem to be sufficient, right? So it's in conflict. It's in conflict with the current statute as read. We kind of know that. So when we say, this is just my opinion, removing it from the listing contract, in my opinion, isn't as big of a deal as the optics are giving, because it's not changing the rules. It's not preventing people from supervising. It's not doing any of that. It's just saying this particular piece is being removed from the contract. Yet you still have your rules, you still have your position statements that still enforce all of those things. It's just saying it doesn't really belong in the listing contract because it's not meeting the statutory requirements. So from my perspective, and I can admit I'm a practitioner as well. I'm a managing broker as well. And yeah, it's nice having this clause in the listing agreements because it makes things easy. It makes disclosure easy. But if it's not really meeting the statutory requirement that we know is in place, how effective is it really? It's almost like I'm gonna use kind of a silly example, but it's like if you have a rule or a law, I mean a statute that says you can't sign cross, right? That's the statute. You can't sign cross. But then in our listing contract, it says, well, sign crossing is okay. It's confusing. So to me, I know there's a lot of conversation about it, and I get it because it's easy to keep it in there. But we've been charged with figuring out a solution so that we still meet the statutory requirement of informed consent, right? But it doesn't necessarily have to be in the listing contract. We can find other ways to introduce that, which would be through rules, as we've discussed previously. So that's just my opinion on it.
Okay, but the statute hasn't changed. The statute hasn't changed. It's been there. So all I'm saying is that I want to table the removal. I'm not saying we're not going to remove it down the road, but I'm saying to table it right now. We leave it in there. We can approve the other changes, but we get a ruling from the legislature on what to do, and then we will know if it needs to come out and how we need to proceed. But right now, the statute hasn't changed. It's an interpretation that has changed. And everyone's interpretation is different. So we need to go back to the legislature who approved the statute and get clarification on this so we know how to proceed. I don't understand why it's a big deal. We've been dealing with this so long. What's another few months? If we can get some clarification and then we go from there, and then we can get everything done properly.
Does any of the other commissioners have anything to say about it?
Well, this has just been, so much to deal with. And I know that all of us have really tried to dive in there and truly understand this. And also coming from the practitioner side, echoing actually quite a bit of what Erica has said, I have always relied on 5.3 when I'm discussing with my clients about disclosure and supervision on that. And as we dive in and start to really understand this, it is not in compliance with the statutes. And so we've been working really hard to try and figure out how do we do this, and so that it is not confusing to the public as well as to practitioners. And I agree, as we continue to look at how can we bring this into compliance, that removing 5.3, although, in my head, I look at it and I think I don't love doing that, it doesn't necessarily change how we would be operating on that fact as far as the statutes, because they're still there. So, and Renee, I'm trying to see what you're saying on that, but it doesn't sound like that's something that we can address in the way that you would want to address that. Because I continue to look for ways, like, how can we do this differently? I just don't know that that's a way that we can do that. And we do have some alternatives that we've been working hard on. They may continue to need some massaging, and we're going to be able to put those out in the proper forums to be able to do that. So I think that it might be reasonable in my mind to continue moving forward with what we have been working so hard on. Those are kind of my comments at this point. This has been very difficult and long in the works, well before I was even on here. And when I look back, there's only one commissioner that's on this board that was here, I think, before the rest of us got here when this thing started. So we're all coming in here secondly. I don't know. Those are my comments at the moment.
Now, that would be another reason that we need clarification. We could put a bill forward to the legislature to get some clarification. And I don't understand what the pushback is on that. We don't, the statutes haven't changed. The legislature approved them. We need to get clarification on these items, on what was meant, how to handle the informed consent, the Rule 6.3G, the 5.3. I don't think it hurts at this point to wait a little bit longer if we can have a bill done that asks for this legislature to give us some interpretation, some help with this. I don't think what we have drafted is perfect. It's going to could affect people in some very negative ways. And we're talking about affecting, our entire industry with this. So I know people are tired of it. It has been going a long time, but that's I think we need to get the correct answers before we change everything.
And if I may, I just want to, this is what helped me kind of wrap my mind around it all, because to Erica's point, I think that we are so used to just going to that particular area, kind of doing that brief disclosure, and then moving on about our business with our clients and our contract. But this is kind of what helped me wrap my mind around that whole blanket consent, as we'll say. If you define what informed consent is, right? It's by definition, it requires that the client fully understands the risks, the facts, and the implications of a specific action or decision, and they must explicitly agree in writing to that specific action. So 5.3, unfortunately, does not allow for that piece, which I think could kind of backfire on a practitioner if litigated, right? If they were found to have not given that proper informed consent, and it goes all the way through litigation. The other thing is part of informed consent, the client has to acknowledge, it has to be voluntary. So it's not automatic. It can't be automatic. It specifically says that. It cannot be automatic. It has to be written, and it has to be specific. So I'll echo that again. So to me, that's why I say, oh, and it cannot be blanket or generic. That's why I say, while yes, we need, we're working on rules to promulgate this whole thing, but 5.3 as defined currently in the listing contract is in direct conflict with what we know about what the statute does say, right? So in my opinion, again, removing that doesn't, it's not affecting supervision by removing that. You still have a duty to supervise. That's statutory. It's literally just taking this blanket consent away, where now we're going to define that in more specific detail. That's how I see it. The other thing I just want to point out, when we're talking about confidential information, because I think there's confusion about what that is too. When we're talking about confidential information, we're talking 5 things. That's it, 5 things. We're not talking about the person's name and their contact information. We're talking about 5 things, and those 5 things are if a client is willing to accept less or pay more.
Well, they're all listed in the
Well, I just want to say them. If a client is willing to accept less or pay more, motivating factors, if the financial terms would change, if they're willing to do something other than they put in their contract, material information, and circumstances that may stigmatize a property. Those are the confidential things that we're talking about, which really shouldn't be written in that contract anyway, really, right? You really shouldn't be putting in your listing agreement that the client is willing to take less. And maybe there are scenarios where those exist. I just can't think of any. There really shouldn't be many instances where, I mean, you're already acknowledging the financial terms in the listing agreements that are acceptable to your client. So anything outside of that, then that is confidential, and that should be in writing. It should not be, it should be separate. It should be in writing. If we talk about stigmatized property, that's typically not something that someone's putting in their listing agreement. So what are we really talking about when it comes to 5.3? And this is why I say, in my opinion, 5.3 doesn't really, it doesn't matter if it's in this particular contract or not, because we still have rules that are going to protect that piece of information. So that's really what I have to say on it. And I know I've talked for a long time, so I'll let anyone else chime in.
Well, multiple people are going to put in their listing contract that let's list it for this price, and then after this much time, let's do this. So there are going to be things in that about it. You could also put something in there about a, whether you want to disclose the suicide or the this or the that. You might want to put that in there so that it is in writing. And the problem comes, if we're going to have them sign something down the road. So there's a form, and yes, you're supposed to do all these things, but we're going to have an issue where they went, oh, I was just told to sign this form and I really didn't understand. And you're going to have a he said, she said on this form. And I think that is going to create a whole nother set of issues. So then who do you believe? The person signed the form, so it must be okay. But they tell you, well, this is my first time home buyer or whatever it is. I didn't know what I was doing, whatever it is. We're going to have issues. I can see back and forth with this form. And that's why I was asking that we get clarification from the legislature so we know exactly what it is that we need to do, what is, what they want, so that we can do everything correctly, so that we are doing the best job we can for the clients, but for the brokers that we serve. So I'm just asking for clarification so we know exactly where to go.
It doesn't sound like we're going to get it from legislature, though. It would have to go through courts to get that. And so
we could do can't we do a bill? Can't we ask to do a bill to get for the legislature? Can't we do that?
Commissioners, this is Gina Simonson representing the AG's office and your general counsel. The motion hasn't been seconded that the chair has put on the table and that we're discussing, and it seems to be a little bit controversial. And the question now on this motion that has not been seconded is whether or not a bill can be put forward, and no, it cannot. If you want to go into an executive session to discuss the best way and get legal advice on the way to get this clarified, we can do that. But I can tell you in public session that the commission cannot propose a bill. Marcia Waters, the director, already informed you that it's too late to include in the part of the sunset process. So that is not a viable legal avenue for you to pursue. So the motion is proposing to table the removal of the current para 5.3 in the commission's form in order to seek clarification from the legislature or to put forth a bill. They are not legal viable options for clarification. Again, if you want to go into executive session to discuss alternatives to get clarification, we can do that. But in response to the motion that's currently on the floor, I wanted to let you know that.
Okay, so Bernadette didn't give an official second, but she said she agreed when I made the motion. So that was a second. So do we
So
need-
let's make that clear for the record then, that Bernadette was a second and that this is under discussion. Your motion is formally under discussion. I just want to
Okay.
make sure that for the minutes that we're clear.
Okay, do
Should
we,
Bernadette be able to confirm that she was actually seconding the motion?
It doesn't sound like that is something that, like, sending it for the clarification. So that's obviously, we can't do that. If it's not an option, our
Well-
option is to go to executive session or decide on it.
okay, so do we need to go into executive session to figure out how to get the clarification?
I think at this point, it would not hurt to go to executive session to be able to get some of your questions answered, in regard to the motion and kind of how you want to proceed with it.
Okay,
So I would,
all right,
happy to motion, that we enter into executive session.
okay. So this is Commissioner Chair Renee Line, Colorado Real Estate Commission meeting on October 7th, 2025. The time is 11:34 a.m. and I move commission enter into executive session pursuant to Colorado Revised Statute Section 24-6-4023A2 for the following purpose: to confer with counsel, to receive legal advice on specific legal questions regarding getting clarification from the legislature on statute. All the, do we,
I'll second.
okay, all those in favor?
Aye.
Aye.
Aye. Okay, so there are 5 votes for executive session, so we are now going to enter executive session. Okay, is everybody back? Erica, yep. Okay, everybody is back. I guess since we didn't have a second on the motions aren't even going anywhere, so I guess Marcia can proceed with B.
So commissioners, as I started to say earlier, like this has been kind of a long process. We're looking at about 6 years of dealing with different issues. What started off with this pattern of some practices that didn't comply with license law. The Real Estate Commission took action against those practitioners, and based on some of the ones that I pulled last week, it was largely the discipline imposed was fining and remedial education. We identified this as an issue to address through rulemaking we started in 2023. We did stakeholder engagement. We filed the rules. They went in front of you in February of 2023. You ended up repealing 6.3G. So today, what you are considering is what we have put together at your direction. B would be draft rules that define what a client is and also what informed consent is. So it would be helpful for us to know if you have any concerns or questions with those proposed rules, how you would like to proceed, because if you want to proceed with those, I can file those for rulemaking, and that would happen in December.
What would be protocol on discussing maybe the portions that we don't agree with?
If you just want to let us know what those are, and then that way we can work through them.
Okay, give me just one moment. I guess the bigger concern that I have with it, with the proposed 6.17 E would be there is a clause or portion of that rule that says that the employing broker must identify another experienced and competent broker within the brokerage firm that does not represent anyone in the transaction or engage the brokerage firm's attorney to provide the designated broker with guidance. So that was kind of more the concerning part that I had in what's being proposed, only because obviously as a small brokerage, you're not going to have a lot of resources. You may not have the ability to identify an experienced broker within your firm, may or may not be able, to utilize an attorney properly. So I had, that was really, I guess, the portion that I was more concerned about on 6.17. Are we addressing all of it or just?
So B covers the definition of a client and then the proposed 6.27, which is the informed consent rules. 6.17 is matter D on your agenda.
Oh,
so
okay. I'm sorry.
the two new rules first.
Okay. I jumped the gun here. With informed consent, I don't really have an issue with that other than, as I've kind of mentioned, having some sort of guidance in the form of a form, which I know is not maybe a popular opinion, but informed consent, I mean, it's identifying the 5 areas that I mentioned earlier. So only in those instances you'd be required to disclose.
And one thing that may come about from this is, even though there may not be a commission approved form, to serve as kind of a template for identifying risks and getting the signature from your client to cover informed consent. there is the opportunity, you never know, the Colorado Bar Association may produce one of these forms. That would be widely available. We have not discussed that with them just because our concern is that we don't feel comfortable producing that type of form within the division. Technically, it's a disclosure form. You guys could create your own. The only thing that you have to deal with when you do those types of disclosure forms is making sure that you do a good job at them. But the rule itself does set forth the different requirements. I mean, you've got to identify the risks.
And I mean, from our discussion, I do want to clarify one thing that Renee brought up that I didn't acknowledge earlier, but I do want to acknowledge it. One thing that she made me think is there are those instances where you might have in your listing agreement, you know, that you're going to list it at a certain price for a certain amount of time, and then after that, you know, there may be a discussion that happens. So that is something that could be in a listing agreement. And so this is just saying, I guess, with that in mind, that you'd have to get, I guess I need clarity. I guess maybe that's part of the discussion, because now does that mean someone reviewing that file, does that need to be redacted? You know, someone reviewing that file, is that information, because it could be deemed as confidential? Could that be problematic with these?
And that was what we were trying to contemplate with the proposed position statement 31, the management of confidential client information by an employing broker.
Mm-hmm.
It gives you some options. It doesn't give you every option, because I feel what has been challenging, particularly with this licensing program, is like, we can't think of every potential scenario that is going to come up for a real estate broker. We try to hit on kind of the high points or the most common issues that may occur. But trying to come up with a solution for every potential problem, we're just not able to do that. So with the position statement, we were hoping to provide some guidance about ways that an employing broker can deal with those different issues, particularly if that information is included in the listing contract. That is something that you could then redact if you don't have the informed consent of your client and you're the designated broker and and your employing broker is charged with reviewing those contracts.
And that's only in the instance where it's an in-office, just want to make that point, in-office transaction.
Well, it would be for anybody though, because if a designated broker is writing in, you know, each week there's going to be a $5,000 price reduction, even though that the other side of the transaction is not being represented within that same brokerage firm, you still have to have informed consent from your client to share that information with your employing broker. It's not just when both sides are represented by the same brokerage firm. The conflicts of interest come up when you have both sides represented by the same brokerage firm.
Yeah, that just further complicates this whole fun process. Because I think that's more of the concern, right? Is those instances where if on every single transaction or every, you know, this has to be disclosed, that's where it becomes kind of problematic, versus like just when it applies. But if it ends up applying 99% of the time, and that's kind of where we want to rely on a form from, you know what I mean? That's where we kind of want to rely on something to give us guidance in the industry. Anyone else? Comments?
I don't think we should create a form. I think that's up to each person, to do it, or if somebody else wants to do it, but I don't think we should have a commission approved form for that.
So what I've heard so far is there's not really concerns with the definition of a client or the actual informed consent rule itself. Is that correct? The concerns arise with 6.17, which is matter D, which we can take these out of order if that's easiest. I know that I put all three of them on the same document. So the concern with 6.17 is E, and just how to manage both sides of a transaction, particularly when the employing broker is a producing employing broker who may not have the resources available to then have another experienced and competent broker supervise the designated broker on the other side of the transaction.
Yes, I have a concern with that one.
I did as well. A similar concern that this, particularly impacts smaller brokerages.
Yeah, it's a significant impact on small brokerages who don't have necessarily the same resources that a larger firm would have. And so it does a disservice to what they're able to do internally, as well as what they're able to, how they're able to assist the consumer, because it creates some red tape that they kind of can't avoid, whereas a larger brokerage wouldn't have as many issues with that because they typically have those protocols in place. And my concern is that there are quite a few small brokerages in Colorado. So this affects, even though, this situation may not occur every day, but I think it still potentially could affect thousands of brokerage firms, which is why, I can't say that I know the exact correction to this language, but I do think providing options would be preferred.
Problem is, what are the options? I mean, if there's a small brokerage, you're kind of stuck.
I think you give similar options that you would give an employing broker that is operating as we'll say a managing broker that's managing transactions within their office, right? They have options. They have a few more options, whereas this one doesn't really provide any additional options. It's like if you're on the other side of that, immediately it must go to another brokerage within your firm, which we may not have that. We may not have a competent broker within the firm to assist with that transaction. Perhaps you can go outside of the firm if you have those relationships, and if you have a relationship with another broker that you would trust with your file, that's questionable. And then another option would be an attorney. But then my concern with the attorney piece is an attorney can definitely give, and I don't know the answer to this, but I'm just saying, in my opinion, an attorney can absolutely give guidance on law, but can they give guidance on practice if they're not practicing? So then that would be a concern. And then lastly, there's no option for the client or the consumer to make the decision for themselves if they're okay with that broker assisting them. So I can give an example of broker A has a relationship with client. They've done numerous transactions with client, right? And they have the listing. Broker B happens to be in that office, small office, but broker B happens to be in that office, has a client that is a buyer, and just circumstantially, it wasn't planned, but circumstantially, buyer B client wants a contract on broker A's listing. In my mind, there should be options of that informed consent. And one of the options, in my opinion, should be if client A and B understand clearly what the risks are And if the piece of information that is confidential, maybe it's, that the individual will accept less, we'll use that as an example. If that piece of information that's confidential is clearly disclosed, all the risks are disclosed, I think that transaction should be able to occur within that office with full disclosure and understanding of all the risks versus it has to go outside of that office and it has to go to another broker. I don't really like that piece of it because then that doesn't, that has a negative effect to me on the clients as well. Because again, if you've had an established relationship and you're okay with the situation, you understand your risk, but you have, but this client is willing to move forward, to say that, for broker A to have to tell their client, I'm sorry, but I'm going to have to refer you to a new broker. I know that you're happy with me. We've done 5 deals together, but sorry, on this one, I can't. It just doesn't feel right. And it doesn't feel like it's helping the public either. So it's like, it's a double-edged sword. It's not really helping them, but then it can hurt them too. So that's where I have trouble with E.
Can I ask a question?
Yes.
I just went into the survey docs. I don't know if you guys had a chance to look at the 6.3 survey responses. It's under column I. How often are both sides of a transaction managed within your brokerage firm? And I realize that this is a very small sampling, but the consensus that I'm seeing is almost never, rarely, never, almost never. And in the time that it did happen, I think it was noted that it's mostly new construction sales. So I know and I appreciate everybody's desire to be very thorough in regards to these discussions to ensure that we're making the right decisions. But maybe we're just talking about a very small subset of what could potentially happen or occur. And I know that we had talked about potentially on the position statements, there could be some additional clarifications that are written and defined for when one-off situations occur.
Which would be okay, but then the language as it stands wouldn't still work, right? Because it specifically says the employing broker must identify another experienced and competent broker within the brokerage firm that does not represent anyone in the transaction or engage the brokerage firm's attorney to provide the designated broker with guidance. That's what this says. So that's where I have an issue with.
So as a public member, which I am, I mean, I don't know the sampling size of the population that we're discussing. How many brokerage firms are out there only led by one employing broker?
I don't have that, but I do know that we have about 4,800 employing brokers in the state of Colorado. I don't have a breakdown of brokerage sizes.
And is it possible for, like, if you are an employing broker and you are the only single one in your firm, to your point, Erica, are you at liberty to go to a trusted advisor or friend that owns and operates another brokerage company and bring them into the fold for when these situations arise?
I think if we're talking me personally, I have those relationships established, right? But if we're talking generally there may be employing brokers that have difficulty, finding someone that they can take that to. So me, yes, but I'm very active. I've been licensed for a really long time, practicing a really long time. So I have those relationships. But if you think just like, again, on a general scale, I can see that there would be employing brokers that may not have those resources or those relationships.
Hypothetically, then, if I were new to the state and opening my brokerage agency, I could, in theory, reach out to an attorney to help me define this and possibly leverage an introduction to somebody who could be helpful.
True. And like I said, my only pushback with the attorney piece of it on certain aspects of a transaction, which, it's just my own theory. An attorney would be absolutely a great resource with law. But if they're not, but sometimes with the practice, then some of that may be a little fuzzy, if that makes sense. Yeah. Unless you're practicing as a broker as well, then they're into the practice. But if you're not in the practice, it's kind of like when we look at a judge, right? In some those cases, it's like the judge understands the law, they may not understand the practice. And so
Yeah.
that would be my concern, even with designating an attorney to help supervise. And maybe that's just I'm being over cautious on that, but that would be my concern.
I just worry that there's been a lot of time that and a lot of discussions up until this point, and I worry that, you know, we're halting progress for a very small subset of population.
Well, the problem is we cannot create a rule that addresses every scenario.
Exactly.
We can't address it that it, you know, because yes, we have an issue with all the independent brokers or single person brokerage, and we can't address a rule or create a rule that addresses every situation. And it's just, that's just how it is. So I don't know how you do this. It's kind of what I said earlier. Do you take part of it out because, or do you, you know, that last sentence, I don't know, or I'm not sure how you do this because it doesn't it doesn't address every situation. So we're not going to come up with a scenario that does address every situation.
Is it possible to put some additional verbiage in there that allows for maybe some flexibility? Like, I know it seems like everybody's stuck on that last sentence of paragraph E. The employing broker must identify another experienced or competent broker within the brokerage firm that does not represent anyone in the transaction, or engage the brokerage firm attorney to provide a designated broker with guidance. When applicable, if possible, is there any way to soften that to allow for some interpretation and flexibility?
So I will offer that I think most of the attorneys that represent the brokerage firms understand how you guys practice. So they should be able to give you some practice guidance. I just anticipate, based on the survey results, that this is like a very minute situation. And like, if I don't understand why, if you've got a long-standing business relationship with somebody, why wouldn't you then refer the new person over to a brokerage firm and you represent the person that you've got the long-standing relationship with? We're not saying you have to dismiss them. I mean, there's workarounds there.
That was just in a scenario where, by circumstance, looking in the MLS, buyer sees this house, just so happens broker A, it's their listing and they're in the same office. So it would be more of that circumstance. So now somebody would have to be removed from that transaction based on this rule.
And
Whether it
that's
be,
only if
you know what I
informed
mean?
consent is waived and the designated broker needs guidance. Now, if it's a designated broker doesn't need guidance, or they don't need to share confidential information, it wouldn't be a problem. There's another alternative, though. Like, if the client is aware that there is this potential conflict that exists because the employing broker is a producing broker and the transaction is complex enough, they don't want to waive their confidentiality, they can hire their own attorney to help them out with that complex nuance associated with the transaction. And so the attorney would be counseling them on how to deal with that, to the point where, like, if it's adding contract language, the attorney would be working with their designated broker to address the issue. I feel like a lot of what we hear at the division is this avoidance of clients having to engage attorneys, but we also see a lot of situations where they should have engaged an attorney. It would have resulted in a better situation than what they are now complaining to us about.
True. Well, am I still the only one that, I mean, because at the end of the day, I know I have a slight issue with that last paragraph, that last sentence. I don't know if there's anyone else. I mean, it may be a moot point if I'm the only one.
I have an issue with it as well, Erica, and just to give some, you know, clarity in our area, and I'm on the Western Slope, but, you know, and it's been a little while since I know exact numbers, but in our area, the bulk of the agents had been, you know, the largest, if you were to say the largest firm, they were independents with, you know, 1 or 2 agents in their office. They were not affiliated with a large brokerage firm. And again, that was a little while ago before I knew that, but that was substantial. And I imagine that if you go around to a lot of smaller communities where they might not have franchises and large offices, that would be something that you would see again and again and again. So although the situation may not come up frequently, the status of very small independent brokerages in rural Colorado, that is something that you're going to see again and again. And that's why this is important to be able to flush through correctly.
But again, is that modification that we can write, that we can mention or give definition to in the proposed position statement?
I mean, to your point, I guess the question is there a way to soften that last sentence so that we can maybe provide further interpretation in a position statement, or, you
So
know,
it's not so rigid and it allows for some flexibility
yeah,
for
Yes.
case by case scenarios?
yeah. Because as written, I just not comfortable.
First, it doesn't give us any flexibility on what to do, and you're kind of just
Just you're stuck with this, and I don't like that last sentence being part of the official rule. But I
yeah.
don't know what to do in terms of
And to those people
take
that
it
are
out. Do we is there language we can use? Do we take it back to the division to help us curate that last sentence so that it's a little, that it addresses some of the concerns that we're bringing up today? I don't know the next step, but I know I'm not comfortable. It sounds like the other Erica's also not comfortable with just how that language reads as it's written.
And I liked what Autumn said, if that's possible, where you're, when available, something along those lines. I mean, this would be best practice, but
What about something like the employing broker should identify another, like should, it's not saying that they absolutely have to find a broker within the firm. I don't know, but I am with you on that too.
We
for
can say
small-
something to the line of the employing broker must attempt to identify another experienced, competent broker within the brokerage firm. And if that's not applicable, engage a brokerage firm attorney. And that if that is not applicable, refer to proposed position statement for options.
I mean, because what we haven't done, and I know there's going to be a ton of pushback on this, but what we haven't done is allowed informed consent in this scenario. But I think that, and what I'm referring to is that scenario that I gave with a broker A, broker B. And again, we're only talking about those 5 confidential areas. So if one, and we're assuming like maybe this person needs guidance on one of those areas. To me, I think it would be, I mean, obviously these other options would be great, like, have someone else enter into the transaction. But if that's not a possibility, having very specific written informed consent that the consumer understands, hey, I'm going to have to get a supervision on this particular issue. And it's complicated because the employing broker, who's also my supervisor, is on the other end. But with your consent, these are the risks, but with your consent, we can still proceed with the transaction and then maybe advise that they, get legal
yes,
advice or something like that. Does that make sense? I hope I'm articulating.
it does make sense if we could do that, and then also put in there, and buyer is advised to consult their own attorney.
Yes. Like something along those
Already
lines.
advise that
where-
in all of our contracts, but it's just reiterated here as well.
Yeah, and that way, when you do have those one-off scenarios where obviously best practice in the position statement could say, hey, best practice is you need to, send it to an experienced, competent broker. I don't think they need to be within your firm. I don't think we can say that because there may be 2 brokers within the firm. And the other broker may not be competent in that situation. So we can say, best practice is to identify another experienced, competent broker engage an attorney, you know, but the third option is if they agree to the informed consent. Obviously, if they don't agree to the informed consent, then they have those other two options. So that's what I think. I mean, none of this is great. None of this is easy. Is like everyone said, we're losing sleep over this. But we have to move on, press forward. I think this is the best, best I could come up with. And it seems like as a group, we're all coming up with ideas along the same line. So,
Marcia, is that even a possibility?
Well, when the employing broker is representing the other side, there's a conflict of interest there. And I believe Irina could probably give you some legal advice about unwaivable conflicts of interest where the designated broker's client, even though they're informed, can't just waive their informed consent knowing that there is a direct conflict with the employing broker at that point.
Mhm.
We can try to work on softening the second sentence. The beauty with rulemaking is if you want to move forward, we can file the rules, work on the language, but like the language is not set in stone until you actually adopt something. And well, there's some other things that come into play, like there's an AG opinion. So if you adopt something that is contrary to law, the AG opinion is going to come back and say, no, not happening. And then the rule doesn't happen. But we can work on kind of softening that language. I don't think that there's a workaround to enable the producing employing broker to have confidential information about the client that is represented by the designated broker. Like that's just going to be one of those situations where you're going to have to look at either they don't share confidential information with you and you navigate the transaction with the assistance, like if it's complex, with the assistance of an attorney, or you refer them to a different brokerage firm to represent one of those clients. Based on just kind of discussions, I don't see a workaround for that one particular scenario. And the whole reason for the second sentence in Part E of that rule was to give you guys some options. You can get rid of the second sentence altogether. I mean, when it's the employing broker that's representing the other side of the transaction, like it says, you're prohibited from receiving confidential information about the designated broker's client. End of discussion.
Yeah.
So maybe removing it.
Might be the best way to go. Because I did have a question too about if we're engaging our own brokerage firm's attorney, then how does that interaction go? Saying, okay, well, you guys represent me, but now I'd like you to interact with this person that I can no longer have contact with, but then we've still got to get to closing on that. It just seems like that's going to be a very bizarre interaction from that point forward. So I wasn't sure how that was even supposed to work when we're engaging the brokerage firm's attorney on that portion of it. I can see saying, client, you're going to need to engage your attorney on that one. And then I can have my attorney telling me what to do on my side, but it was going to be a little more difficult there.
So how about, like Marcia said, we just take out that last sentence?
Mm-hmm.
And
I agree with that.
I much prefer that.
And then it's not tying anybody to a specific scenario that they have to do that. Then they can, use another trusted broker. They can interpret that, I guess.
Okay,
Yeah.
so Marcia, that's not something that you can get changed and we can look at it next meeting?
Well, so if I eliminate that sentence, I can get these 3 rules filed so that you can do rulemaking at the December meeting.
And I do have a question about rulemaking. My understanding too, and this is just a thought I had, which I think may be good, but that's kind of open too. So there could be people in the industry that have insight and thoughts that we're not privy to at this moment. There may be some ideas and thoughts that come about then that, in that process. So I don't think that's completely a bad thing. It can be overwhelming, right? To get all the thoughts and opinions, but at least if there is something that maybe some idea, some thought that we're missing, we might see it through that process. Is
That's a
that
good point.
accurate?
So
Yeah.
when we engage in rulemaking, the agency is required to engage in stakeholder engagement, and we have changed how we do that. So what will happen once the rules get filed and between the rulemaking hearing in December is we will conduct a stakeholder meeting, which will send out notification to the industry. Anybody can attend and provide comments. We record those, so we will make the recording available to you in advance of your meeting, and you can listen to the testimony. They'll have 2 bites of the apple to provide basically their comments. There will be the stakeholder meeting, and then if they also want to show up and testify at the rulemaking hearing, that will be the opportunity as well. But they will have 2 times to offer their opinions. Unless they also want to do it, they can testify, submit written comments, and also attend the stakeholder meeting. That gives them 3 opportunities to make themselves heard.
Okay. I like that part of the rulemaking, although I know it complicates it, but I think that if we've left any holes, that it could maybe fill in some blanks that maybe we're not thinking of or that didn't come up in our meeting. So I don't know if we're ready for a motion. I would be willing to motion on the 617. I know we're out of order, but I would be ready to motion on
I
that.
did have a question on D.
Oh, okay.
Unless we want to do it in discussion after the motion.
No, go ahead. Go ahead.
It just seemed like it was, and I could be wrong, and I just have a note that it was written for, where did it go? It's written as if the disclosure of conflict of interest would be made following the sharing of the confidential information. So I just didn't know if just a word or 2 needed to be changed in there somewhere, because it says, if the employing broker supervises the designated brokers that represent both sides of the same transaction and confidential information about one or more of the clients is shared with the employing broker, the designated brokers must disclose this as a conflict of interest. So it's kind of like coming after the fact. Is that the intent there, or?
No, we can change that language to will be shared.
Yeah.
Instead of is shared.
Because I thought we needed to do that beforehand. So, okay, that was my only comment on that one.
Okay.
Okay. And that just further clarification, that's one of those areas where if someone is in an office where there may be constant transactions, so that would be more of the larger firm, right? Where they may have more scenarios where you have same transaction, 2 different brokers within the firm, but then they can curate their own forms for when those scenarios take place.
It could also be a small brokerage firm. You could have 3 brokers where the employing broker is supervising both.
Yeah, but probably more, I'm just saying most commonly that's with the, firm with more agents, but the direction we're being given, because I think my desire for a standard form has pretty much been shot down. So the direction that we're being given is, and I know some of the commissioners feel that it should go this way too, is that those particular offices, or maybe, maybe the bar association, but someone will provide a disclosure that can just be used in all of these scenarios. Okay.
And I also had just a question here too. We're using the term, obviously employing broker quite a bit, but a lot of the larger offices have an employing broker that does no supervision, and then a supervising, supervising broker. Do we want to have any terminology in here that is kind of referencing those? Because you might have that supervising broker that's the one bringing that other offer. Or are we just going to only go with employing broker?
So there's definitions in chapter 1, and employing broker is one of our definitions. They can delegate their supervision to somebody else. It's got to be in writing. And that's fine, but so if it's been delegated, then basically that informed consent, it kind of transfers down to where that supervision has been delegated as well.
Okay. Thank you. Just wanted to make sure we're covering all of that now.
So it sounds like I know what to do with the 3 rules: informed consent, the definition of a client, and 6.17. So I will go ahead and make the changes that you requested and get those filed with Secretary of State so that you will be having the rulemaking hearing at your December meeting. That moves us to the position statement. So C is the proposed position statement. Number 31, management of confidential client information by an employing broker. Questions or concerns about that one?
I think here, and bear with me, I have to find where it is. It's going to be the same issue that was just raised in the rule. So as long as those two match, where was it? Let's see.
It's the conflicts of interest section is where it should be. So
yeah, so that second part, that last paragraph, it looks like.
We can make modifications to that. And I can probably get you a red line before this meeting is over.
Okay.
To take out kind of the position statement was there to provide some guidance, but if you would just like it to be clear that you can't share the confidential information and they're kind of on their own figuring it out, we can do that.
I felt like there's a statement in here that says, I'm trying to figure out where that was at. It just seemed a little unreasonable to put in there. It says that the designated broker must anticipate any possible issues that may arise. And that just kind of, I mean, as much as we would love to do that, I wish I had that crystal ball. It just seemed a little unreasonable.
So we can soften that.
Yeah, that's a great point, actually.
And there was another area that says that we are expecting employing brokers to anticipate how to perform our supervision duties absent a client's informed consent. I guess it just depends on, I don't know, let me find that too. It really depends on the deal and the transaction and what we are doing.
Was that under the conflict of interest section too, or?
I'm trying to find it. I should have wrote a note as to where that was at.
Commissioners, I'm sharing a screen with that highlights that specific language, if that is of any assistance to you.
Yeah, there you go. It's right there.
Thank you.
Yeah, I would take that out.
And I'm sorry, now that I can read it, which part were you wanting to remove?
Just an employing broker needs to anticipate how to perform their supervision duties absent a client's informed consent. Because we're going to work on getting it if we need it, but it's hard to put just a blanket statement of what we're supposed to do without something we don't know what it is.
Yeah. So is that something that can be removed, Marcia? Okay.
So just for clarification, which part are you talking about removing?
Got it on the screen here, if you're able to see.
Right, but which,
Just the one line in there at this point. An employing broker needs to
Okay.
anticipate how to perform their supervision duties absent a client's informed consent.
okay,
Are we striking it all together or adding to the best of their abilities or?
I think strike it.
I think take it out.
Okay. So and I was trying to find the area where the other thing was removed, or we want it removed. Because I thought you brought up a good point. Was the first thing.
Yeah,
I'm trying to see where that's at.
the statement about must anticipate any issue that may arise.
Yeah. Okay. So that was under 3. I see it now. Thank you.
and can we just add an and? I know it's tech, on that second paragraph, second line, it has a comma, the preparation of contracts. Can we add an and in there? And the preparation of contracts and monitoring of transactions? Up in this, the second paragraph from the top.
Mm-hmm. Anything else? Anything else with this one? And I will work on edits while you guys go through investigations and licensing matters, and you can see the edited version at the end of your meeting.
Sounds good.
Yeah, I don't
That
see
sounds good.
anything else.
So then that leaves us with CP 22's revision. And I will tell you with this position statement, so the definition of a conflict of interest was adopted in February of 2024. So the first edits is just making sure that that is the same definition as what is in Rule 1.13. The change to number 3 is to align with the statute language as far as general partnerships and limited liability companies. And then we tried to kind of marry the different drafts of the rules with the language in this position statement as well regarding conflicts of interest.
Can we scroll it down just a little bit and just pause there for a second? Yeah, so we could see all the changes. Like, go down a little bit so we could see, or scroll up, I guess, on your end. Scroll up so we can see down. Okay, just so we can, because my version wasn't red line, like it. I had, yeah.
Yeah,
I
mine
have the
wasn't.
markings on it, so this
Ew,
is,
yeah, mine was not, I didn't have this red line or blue line.
yeah, so this is easier to see the changes. Okay, anyone have any concern about the first one?
Nope, can we go down to the next one?
Okay. I don't have any issues personally with those.
The next one.
I don't have an issue so far.
Okay, so if there's no other suggestions on changes, looks like we're good to go on CP 22.
Yep. So is the commission okay with adopting this today? CP 22?
Yes.
Yes.
Yeah. So
Yes.
you'll need a motion and a second and a vote.
Yep, someone want to make a motion?
I motion to accept the proposed revisions to commission position 22.
Okay, is there a second?
I'll second.
Second. Oh,
Okay, any further discussion? All those in favor?
Aye.
Aye.
okay.
Any opposed? Okay, motion passes. Okay, so are we done with, oh, we still have agenda items for the next meeting?
And if you guys want to kind of table 31, position 31 for the end of the meeting, I will have your requested revisions by then. But yeah, is there anything that you would like discussed at your next meeting other than you will be having rulemaking?
Should we discuss the topic? I don't want the public comment to be unnoticed. Should we have a discussion about the public comment that was made in regard to the misleading information in the listings? Is that appropriate to have as a discussion? I don't know, but I want to acknowledge it, and I don't know if it's appropriate to do it on the agenda.
And you're referring to the one raised by Lori Miller,
Yes.
not the one raised by Ray Brianza.
Well, we can address both.
So we can put those on your agenda for the next time.
Yeah, we could address both. You're right, because there was.
I thought about suggesting that we ask her to file a complaint on it so it can be looked at. I don't know if you guys want to do it that way, but if we can just discuss it and see, and then, but I don't even know if that's legit to say to file a complaint, but we don't want it to keep coming up either. So.
Yeah, but at least we can have a conversation about it next meeting and kind of figure out those two things that were brought up.
Okay.
Commissioners, and if I may, I don't think we made a motion regarding policy matter B and D. We discussed, we came to a conclusion. but I didn't hear the motion being made, being seconded. Is that accurate, Marcia?
Yeah, I don't think we did.
They didn't do a motion, but I
Yes.
didn't know that it was necessarily needed since, I mean, ultimately they'll be doing rulemaking and they'll make an official decision once the rules are filed.
Right, but maybe a motion to direct the division to move forward with rulemaking proceeding, just so we are keeping a good note of our meeting.
That's fine.
Okay, does someone want to make a motion?
It was a motion to approve the commission to move forward on items. It was C? No, we're coming back to that. Excuse me.
On Rule 6.17 was.
Which is agenda item D and agenda item E.
Yeah.
Okay.
No.
And then also
It's agenda item D and B that I
B like
believe.
boy. Thank you. I apologize. I move to approve the commission to move forward for rulemaking for the December meeting for agenda items B and D.
Second.
Okay. And any further discussion? All right, all those in favor?
Aye.
Aye.
Okay. All right, motion passes. Okay, it looks like we're on to the non-rulemaking hearing. Are we doing okay? We gonna move? Anybody need a break or are we gonna go forward?
I wouldn't mind taking a break just to get a little snack or something.
Okay, how about if we take like a 15-minute break? Let's see. Well, what do we think? Back at one, I guess 15 minutes would be 107. What do you guys want? 110?
Sure, maybe just like a.
Okay, we'll be back at 110.
Thank you.
Okay, is Erica here? Yep, okay. All right, so now we're going to work on the non-rulemaking hearing. So the Colorado Real Estate Commission has the authority to promulgate real estate forms for current use by real estate brokers pursuant to section 12-10-403 CRS. These forms are referred to as commission-approved forms. The purpose of this non-rulemaking hearing is to hear oral testimony and accept written submissions relating to the following commission-approved form. We're going to look at manufacturer home addendum to contract to buy and sell real estate. In addition to my fellow commissioners, here with me today are Director Waters, Deputy Director Lyle, Senior Advisor Phipps, Board Liaison Doreen Archuleta from the Division of Real Estate, and Gina Simonson and Irina Groni from the Attorney General's Office. The public record will consist of all testimony and any written information submitted within the allowable time frame. In addition to the public comments today, the Commission will review any written materials to make the final decision on the proposed new and modified forms. The public record will close at the end of this hearing. Let's now have Senior Advisor Phipps explain the proposed modified form.
Thank you, Madam Chair. As Commissioner Lind noted, the first form before you today for your consideration is the manufactured home addendum to the contract to buy and sell real estate. And as an initial matter, I just wanted to check in with all of you commissioners and see if the version of the form that was in your materials contained red lines or not. It did not. Okay, so that would obviously probably be helpful. I don't know, David, if you are, let me see. Okay, he's got that up.
Line, forgive me, Ms. Phipps, the red line is available on the shared screen presently, yes.
Okay, and I will trust you can scroll along with us, but I don't think I'll have to really point out anything specific for you. But thank you for putting that up, I appreciate it. So this form, the first thing that you'll see about it is the new header that is going to be on all of our forms now moving forward. This is the same, this header contains the same changes that were on all the other forms that you saw in the August meeting and that you approved on the forms during the August meeting. So again, that header is the same. All of the proposed revisions to this addendum are conforming changes, and those changes reflect the changes to the manufactured home contract to buy and sell lot lease only that were approved by the Commission at the August 2025 meeting. So the changes that you see before you today that David's kind of scrolling through, these are made to make the two forms consistent. None of the changes are substantive. They're all changes really just to wording and some of the titles. Like there's a title on there and 7.1 that didn't need to be there. The one thing that I did want to point out, which you guys haven't seen before today, I don't think, is if David, if you could go to paragraph 10.3, please. Sorry not to put you on the spot. Let's see if it shows here. I don't know why that paragraph 10.3 is stricken and replaced with 8.3. That's obviously, I think, a mistake that I must have made at some point in time, because 10.3 is in fact the correct reference. So I will not be making that change on the finalized version. I will keep it as 10.3 and not make the change to 8.3. So that's about it for this form. If you have any questions, I'm happy to answer them for you. Otherwise, I'll turn it back over to Commissioner Lind.
Okay, thank you, Melissa. Any comments or questions from commissioners at this time before we ask for public testimony? Okay, at this time, we'll start with the testimony phase. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization you're representing, if applicable. Finally, please limit your testimony to only the proposed new and modified form under review today, the manufactured home addendum to contract to buy and sell real estate, and do not duplicate testimony. Should the commission or any of its representatives have a question regarding your testimony, we will ask when you have finished your testimony. If you desire to provide testimony, please raise your virtual hand so division staff know who to call on. And David, is there anyone wanting to speak?
Similar to public comment previously, attendees, you may select the raise hand icon out of the Zoom platform. And commissioners, if you'll just give it a moment, we'll see if anyone elects to discuss this form.
Okay.
However, I'm not seeing any.
Okay, do we have any discussion with commissioners, or would anyone like to make a motion?
I'm happy to make a motion.
Okay.
I motion to accept the manufactured home addendum to contract to buy and sell real estate with the proposed correction at paragraph 10.8.
10.3.
10.3, sorry.
Okay, do we have a second?
Second.
I'll second.
All right, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes. Okay, so we're now going to consider proposed modified forms. We're going to be considering forms that were held over from the August 5th, 2025 non-rulemaking hearing, when these forms were initially proposed and commented upon by the public. The comment period for those forms closed August 5th, 2025, so there will be no more public testimony today on the forms tabled from that prior meeting. We are specifically going to look at exclusive right to lease listing contract, exclusive tenant listing contract, exclusive right to buy listing contract, exclusive right to sell listing contract, and closing instructions. Do we have any discussion, commissioners? The only thing I saw, we have the adoption date. We need to make sure the adoption date is today instead of August 5th.
Good catch. I can make that change.
Okay. So any discussion on anything? Any of the changes, or do we have a motion regarding the proposed forms?
I didn't have anything. Anybody else?
Are we discussing the closing instructions right here as well? Just going through?
Yes. Yes.
I did want to talk about those a little bit because we had some questions as to being able to confirm the other side. So, and I do think that that was a really valid point that was brought up, and it is very difficult. I mean, we go through the entire transaction with more of a confirm, get it in writing, make sure that you know everything that's happening on this, and then we get to closing. And we have no way of knowing on the other side. We're not able to see the seller's statement if you're on the buy side or vice versa, to make sure that the seller is maybe paying off that solar lease, or the home warranty is paid for, or any number of line items that might be paid. And I don't know that the closing instructions is the place to take care of that. But I did want to bring that up, that was a proposal, because again, this goes back to confidential information. So I did at least want to bring that up. That's something that we should be potentially working on. And I know that it's been recommended, well, we could call and ask, and we can. And if we've got, you know, a title officer that is really on point and we're able to go through that, but we don't have any way of verifying it right now. And I don't know, I just like to bring that up for discussion. I don't think we can fix that right now in closing instructions, but does anybody else want to chat about that?
I'm happy to chat about it because I know that came up last meeting as a concern. I thought that what was in place, if we go to section 18, I did kind of mark some of this language still. So the discussion that we had last meeting, to your point, is that it is challenging to get for example, if you're representing a buy side, a lot of title companies will not allow you to see the seller statement, which the problem that can create for that broker anyway is, as to what you were just saying, Erica, the inability to now verify fees that are supposed to be taken care of on that side. So the language here, I think, gives a little light direction that it is okay to provide that information, because what a lot of the title companies are holding to is, well, they feel their interpretation of the rules is that they only have to give the prospective broker the settlement, and their interpretation often is that they're not able to give it to the other agent, which I don't think that's it's definitely not how I interpret that. So this, to me, is seeking to kind of broaden that, I think, by saying closing company is authorized by buyer and seller to deliver their respective closing statement to the respective brokers, right? I guess the language is where I had a question, because I'm like, it is confusing to me when you say the respective brokers working with them in the transaction.
And I'm taking that as it can go, if you're working with the buyer, you get the buyers. If you're working with the seller, you get the sellers, but you don't get the other one.
And maybe is that the intended meaning, Melissa? Because I thought from our discussion, we were trying to kind of open it up that you could get it.
No, I think the intent of that language change is exactly what Commissioner Doyle said. That the broker gets their own party's statements.
Okay.
And not the other parties.
You can ask for it, though. You're just not automatically entitled to it.
Yeah, and that has been a little bit of an issue, because that's exactly how it's being interpreted. So maybe when I misread this, because I couldn't see the line, it looked like I thought we were saying that one or both of the brokers could have that information.
Well, and in section 4.3, we have closing statement where it's talking about the closing statement as well. And I had thought that there was a little bit of conflict here, but I'm being told maybe not. If I'm looking in here, closing statement will be prepared in accordance with the contract and written instructions from the buyer, seller, lender, or real estate broker, so long as such written instructions are not contrary to the contract. If the written instructions are contrary to the contract, the buyer and seller must execute an agreement to amend, extend. I'm sorry, I'm reading the wrong one. Will prepare and deliver accurate, complete, and detailed closing statements to buyer, seller, and the real estate brokers working with the buyer and seller. Sorry, I started at the second sentence instead of the first one. So in that one, I feel like it's a little more open that it could go with the real estate brokers, but it's still kind of tying it to just the one working with that client. And again, this is tied more into confidential information. But my problem is definitely making sure that we don't go past the closing, if at all possible, and miss those items that our client was supposed to either pay or receive. And when we get past that point, then we've got a real mess, which we will see coming up. We've just got, it's after closing that's the problem. When if we had the opportunity to verify these line items prior to closing in writing, one, we're able to do this and document that we did this for our clients, or document that we missed it because we saw it. or not. Right now, we're not able to do that. Is that something that we can address in the closing instructions, that we're allowed to get each of these or not? Marcia, is that just a hard pass?
I don't think it's a hard pass. Like I said, you can ask for it. It's the whole entitlement thing of you're entitled to both sides. Because maybe that seller doesn't want your buyer to know what their proceeds are when they walk away from that sale.
So then if you're saying we could ask for it, then can we go ahead and just remove where it says respective brokers in the closing instructions so that we don't have that as an argument per se? Because they can still say no, but it gives them one more opportunity to say, we just want to confirm that X, Y, and Z is paid.
Yeah, and I will say there are, I know one in particular title company won't even give the disbursement statement. Like, some prepare a disbursement. So it's not the settlement, it's just a disbursement. And then you could verify fees there. And I know for certain there's one title company in town a big title company that won't even give that. So it does make it complicated because, and then the other thing, I mean, not that this is too difficult to navigate, but you're kind of forced to remember every, little detail, where it's kind of nice if you could just visually see it and comment on it. And I do agree that it really isn't something that needs to be shared with a buyer, because I do think that it's not something that the buyer needs in their closing file, but it is something that is useful for our purposes. And there are title companies that are very good. Once you ask for it, they give it to you. And then there's others that, through their attorneys are being advised not to. But I think in that instance, the title companies that are being advised not to, they are pointing to the statute that specifies that it's the respective broker. And although when you look at the files, what needs to be in our files, it's giving us a minimum, right? The minimal things that you need in your file, but obviously in most instances, you're going to have additional documents in your file that aren't required by the division. And so they're interpreting, because it specifies the specific documents, that they don't have to share that information because it's not listed as something that we have to have, even though it's something we can have. Does that make sense?
So why not just reach out to the other broker and ask for a copy of their settlement statement for their client, and then that way you cut the title company out of the loop?
Because at that point, then it seems like the issue is back to confidentiality. Do they have permission to give that? Do they have permission to give that to us? Whereas if
going direct too, sometimes we don't even get that till the last minute. Like, we're really trying to get those numbers in order very quickly. So the title company they're the ones that can also make those changes very quickly as well and make sure it's accurate. So they're the kind of the last person before everybody's bringing in the money or dispersing the money. They're also the ones paying those bills.
Well, being able to see what is on the settlement statement can help some of those issues from coming in front of the board. So like if they have a warranty that's paid or wasn't paid, if it's, if it was in the contract or wasn't, or whatever the problem was, like we'll see one of those anyways. It ends up here with us. So if they can verify that ahead of time, it would be helpful.
And I think that title companies are going to have their own they're going to have their legal advice, right? And they're going to go with that. But I just caution using language that makes it seem like we're unable to get that information. I just think it needs to show that we are able to get it at their discretion, if nothing else, right? So to me, this does read, and I apologize because I read it wrong earlier, but it does read that we don't get it at all. So I think we're gonna have more title companies that say, oh, no, based on the closing instructions, we can't give that to you anymore.
No, I'm not the one that drafts the contract language. Do you want Melissa to include something that the respective party can ask the other side for a copy of their settlement statement?
I think that would be good, being able to at least leave it open enough that the title companies understand that it is something we can ask for. It is something they can provide. It's not against the law to provide that. Now, if they've gotten advice otherwise, that's fine. But I think some of them are interpreting this, even as it stands currently in terms of the rules and the statute, they're interpreting it as they cannot give it to us.
Marsha, it would be probably not respective parties, but the opposite parties can ask.
So do we need to say can ask, or do we just need to say may receive a copy upon request? That way it's clear that they
I
can
like
receive
that.
it.
I like that language where it's that we can receive it upon request. I don't know if in title, I don't know, and I'm trying to think back when we had the public discussion. I don't recall any title companies chiming in too much. I don't know if that.
The issue I would see with that language is I think that flips it back to the original language, which implies that if you request it, you automatically get it.
Right.
And that takes out a party's ability to object.
Right.
Can I ask a question? And with this new changed language, is it essentially stating the obvious? Meaning, does a closing company automatically deliver the respective closing statement to buyer's broker and seller's broker?
My answer to that would be it is not automatic anymore. There was a time where it was automatic. It's not automatic anymore. There are some companies that will send it automatically. There are some that will send it upon a request, and there are some that won't send it at all.
And some just give it to the broker. They don't give it to the buyer or seller. They give it to the broker.
Correct.
So you're kind of dealing with 3 different circumstances of how we obtain that. But the point of it is being able to get, our purpose of, I mean, I would even be okay, if they redacted the proceeds. I mean, it's just, we need to be able to see the fees that affect the buyer. I mean, if they miss a solar panel payoff, it's huge. That was negotiated maybe at a inspection, so maybe it wasn't there in the beginning, but through negotiations, it came later, and oops, the listing broker forgot to put it on. Like, those are big, big, big issues that, to Erica's point, would be very problematic, after the fact. After, once you disperse funds, it's a whole issue trying to ask for money back. So I'm not really sure how it could be worded, but hopefully we've at least articulated our concern and our problem.
Yeah, I think even if they don't show what the proceeds are from the sale, they don't have to show that number, just what the line items are that they're paying to make sure that it's listed on that settlement statement.
Yeah. And there's some that won't do that at all. They won't even give the disbursement.
Yeah. Erica, would they validate?
You
Right.
can, so what they say, I'm thinking one company in particular, what they tell you is you can send them an email um, asking about all the fees, and then they can respond.
But so they could validate any concerns that you might have, even though you're not physically getting.
In
the
theory,
scope of
yes.
review?
In theory,
Okay.
yes. But then I guess I kind of went back to why it is nice when you can see it, because sometimes there's those shared fees, split fees that maybe you might miss if you're not visually
Yeah.
seeing,
Until you see
some
it
of those-
on that form, it's not on the form. Like I have multiple emails that I'll go and I'll be like, hey, make sure this is on the settlement statement, make sure this is on there. And then, it'll come back and they're like, oh yeah, I didn't see that email. And it's like, it's just until it's on that settlement statement, it has not been processed. And then you just don't know that check's not being cut for any of those different things. And that is the best resource we have for validation that those are being done correctly, or the prorations are being, like leases, security deposits, prorations for rents, any of those things that would be on there. Unless you see it on the settlement statement, you don't know that it's accurate on that seller side being transferred over to the buyer.
Yeah.
So how are you verifying things that are paid outside of closing? That aren't escrowed with the title company?
They're on the settlement statement.
They're on the settlement. They have to be.
Yep.
So like an example, real practical example, radon. Sometimes scheduling radon is challenging. So it's agreed upon, but the radon mitigation company can't get out until a week after closing. And so a lot of times that's negotiated as part of the seller side. It may be a scenario where the seller is going to pay, they'll cut the check, right, to pay that radon mitigation company. And
I think
then
Marcia was asking about things that were paid outside of closing, maybe ahead of time. Like say you paid a handyman, X amount of money to repair XYZ. I think maybe I'm wrong, but I think that's a
No,
Marcia.
that's on the settlement statement.
Yeah,
Well,
like
you could pay the handyman outside of closing, and then you would ask for the receipt. You would ask for the receipt, and that needs to be written up in your inspection resolution to provide receipt at closing.
for that, but then there's the other scenario where things are truly paid outside of closing. But they're part of the agreed transaction, which is the example I was giving, where you have that radon that can't be scheduled until after, but maybe because of rate locks and various scenarios, you can't push closing. It wouldn't make sense. It would do more harm than good to push the closing. So those things are handled outside of closing. Well, now that's going to be on the seller side of the settlement, and you can't verify that if you're not able to see it. I mean, you can send an email and those sorts of things, but
The settlement statement ensures that it's done.
yeah, you can physically see, okay, I've confirmed this is done, because I feel as if you're on the buyer side of that transaction and you, for whatever reason, weren't able to verify that comes back on you. Right?
Okay,
The title company
Buyer's agent.
is holding that money. They've collected those funds.
Okay. Is there, Melissa, do you have any recommendations, since you didn't like what they said about, that the other party can receive it upon request? If you don't like that, is there some other thing, or they can receive it upon request if something's redacted? Is there some solution to this, or?
I was thinking that maybe at the end of that existing paragraph, you could add something like, if requested to do so, or upon request, a party may authorize the closing company to release a copy of their settlement statement to the other party or other party's broker. And maybe you could add something like, with redactions as necessary, or something about they have the ability to approve the release with redactions. I don't know. I don't know that's necessarily a question for me to answer, but that's the best.
If they're going to approve the release, we might as well just call them directly and say, hey, send me a copy. That'd be easier, probably.
Right.
Well, would it make sense to put the reasoning behind the language, meaning the ultimate objective or goal of this is to avoid, scope gaps upon closing. So it could be solar, it could be radon, it could be all these things, but really it's the selling broker's reasoning is to ensure that all of the scope has been captured and that we're not going to have an aha moment after closing. I think if you can explain it to the title companies why you're asking for it, you're not trying to get, confidential information for the sake of leverage. You're doing this to ensure that the sale goes appropriately, thoroughly, and captures all the scope that's been negotiated and agreed upon. Just an idea.
I like that idea. Put it in there. Why? Is it? I'm trying to think of how to word that.
And just to verify final transaction numbers. And
that all negotiated scope has been captured. Yeah.
To ensure all payments. I don't know.
Keep it very simple.
To ensure to ensure all payments, or I don't know, something have been accounted for. The other party can request a copy. Oh, it's too wordy.
Is to ensure proper accounting. Is that accurate?
That's
Just
good.
leave it at,
Yeah.
okay.
But we're still getting into how do you phrase it? If you say, we're explaining why, but we still need to get, if we're going to say that they may release it upon request.
Well, can't we put that in here that this is them allowing them to release it because they're signing it, the title company is signing it, and it's telling them why in here. So full disclosure, we just need to double check the numbers.
I mean, if needed, you could put in in parentheses, common examples that you guys have already brought up between solar, radon, whatever that is, and you can say etc. But these are things that are most often missed and not verified.
So if we just have it in there that they can release it to either party and everybody signs it, is the problem now that doesn't meet informed consent? Or because if we put it in there in writing and everybody signs it, are we good to go? Because now we're having buyers and sellers sign this. And if they all sign it, they're acknowledging that it can be released to either party.
Well, it's important.
Did you have an issue with what Melissa proposed for the language?
Can you read that again, Melissa?
If requested to do so, a party may authorize the closing company to release a copy of their settlement statement to the other party or other party's broker.
But is that requiring an additional authorization? Like,
yes.
It's pretty timely when we're needing these. It's at the last minute. So then we're having to track down an additional authorization. People are packing, moving. I mean,
I think it is an extra step. It could work through like email, right? So in theory, a title company could, a lot of times they'll send like a group email and say, to the seller side, do you authorize me to provide XYZ? I could see that kind of working, but the other thing I was just thinking, would it make sense? Because while I think it's super important to see the settlement statement itself, I think also because the title company's handling all the numbers, maybe we put it on them to provide. So there would be like a sentence so we leave this as it is, but then there would be a sentence that says something like, additionally, buyer to be provided a list of, I don't know how we would word it, but what I'll tell you what I'm trying to say, but a list of fees that affect their side or something like that, right? That could be maybe an added sentence if we want to leave it this way, and then just put it on, you know, them to provide the buyer's side with however they want to do it, whether it's an email, whether they have a form, but just something, if they don't want to give us that settlement, something that shows all of those fees that affect the buyer side. Just another thought. If we are getting in the weeds too much with the title company, you know, and what they are potentially going to be willing to do and not do. Because again, I know that one company I haven't mentioned, but I've referenced, they say that it's their attorneys that won't allow them to do it. So we still may get pushback in those instances, right? So, but maybe it would put it on them to provide us with a list of those fees if they don't want to give us a settlement.
Well, Eric, in a situation like that, I mean, could a small clause leveraging that language? Because to your point earlier, you said that if this fails to happen and then there is a boo-boo at the end of closing and something was missed, it falls on the broker when they were powerless to control the outcome. So I'm curious then if you can say if title refuses, then it kind of recuses said broker because they asked and were denied. I don't know if that makes sense, but
yeah,
Can we go back to what Melissa, the sentence, Melissa, can you read that again? What you were going to suggest?
Sure. Hold on. If requested to do so, a party may authorize the closing company to release a copy of their settlement statement to the other party or other party's broker. And that's a little bit awkward. It could be upon request, or I don't know, it could be massaged obviously a bit.
But what you're saying,
upon request, I think that's good.
But upon request does to the title company, but Melissa, what you're saying is we still have to get authorization from the other broker.
Correct. Yeah,
so you don't think it would work if we just say upon request title company to supply a copy of, document for, to ensure proper accounting? You're saying that would then contradict what it says?
Right. I think that is that's taking it back to the original language, essentially. As an essential point, the original language is you're given both sides, both copies. And all we've done is change the language, but then with the second added line, we're just saying, but we're going to give it to you upon request anyways. I just think it makes the change that we're making.
Is this because of informed consent? Is this why we're changing it? Because of informed consent, or we have had problems, or, because, in the old days, it was all on one HUD and you passed the HUD all the way around the table and everybody signed, everybody saw it. So is this because informed consent or a problem, or why are we doing this?
Because we could be, once again, just putting in language in the contract that could provide for an automatic disclosure of potentially confidential information without essentially having informed consent.
But okay, if we look back at confidential information, we have those 5 types of confidential information. What is going to be on that settlement statement that falls under one of those types? Nothing, right? It's a done deal at that point. There's nothing confidential information on the settlement statement referring to any of those 5 things. So I'm questioning why we need to do this.
Maybe it's just proceeds. Maybe they're just trying to block out what the proceeds.
But
so is there a way to put this without disclosing proceeds?
But that's not a confidential information.
I do think that there's a benefit to not having the parties see each other's proceeds.
And I think it gets back to, I'm sorry to speak over you. I apologize.
Oh, no, that's okay. I do understand that piece though, because if a buyer is getting money back at closing and a seller paid concessions, you kind of don't want them to see that.
But we're
And
not saying we're going to give it to the buyers. We're saying we're giving it to the buyers. We're saying we're giving it to the brokers.
right, I'm just giving examples. And then if the seller is getting like a huge amount of money back, and then the buyer may feel like, oh, well, they wouldn't negotiate with me, but they're getting all this back. You know, I could see why they don't want that, which is why I said maybe
You're
they could
closing, it
redact it.
doesn't matter.
It's like they could redact that information because they may find that to be confident, like information that they don't want to
Well, nobody wants to know, nobody wants anybody to see how much money they're getting or making or, you know, so I mean, however, if it would still said provide settlement statement with redacted, with any proceeds redacted, I don't know.
or any necessary, I don't know.
And I just wanted to not to take a step back, but I just wanted to kind of point out in response to Commissioner Lyon's question is, I think this speaks to the balance that we're trying to strike between making things easier and consumer protection. Yes, I get it that this is a big issue and it's easier for the brokers if they're just automatically handed a copy of the other side's closing statement or settlement statement. I understand that as a practical matter. But in order to make things easier, are we just going to ignore the consumer's interests in not having?
But it's not hurting the consumer.
For example,
just because they see what proceeds they're walking away from, you got your deal. You've got your price, you've got your, whatever it is, you've already agreed to all that. It shouldn't matter what they're walking away with. That doesn't hurt the consumer. The consumer has negotiated all their part of it. It's not hurting the consumer. So that's why I don't know why this has turned into such a big deal.
So would it be reasonable to move forward with the language Melissa gave with the understanding that there's probably going to be an added step of some sort of email, like authorization or something like that, to allow the buying broker to get that settlement? Because I think we're at an impasse right now, so I'm just trying to kind of move forward one way or another. Does that seem reasonable to everyone, or does that seem, and I know it is an extra step, but I would prefer that than the language that's here.
By request, brokers can receive a list of all items on settlement statement. That's just giving them a list, not
maybe say an inventory.
Commissioners, like if this is so problematic, you can just go back to the existing language in section 18.
Let's do that.
Well, and I yes, I would love that. I just thought it had to come out for some reason. So.
Well, so let me ask you this. What happens when you find out, like at the closing, that something was not escrowed that was supposed to be escrowed? What are you doing then?
Making the correction prior to signing.
What if they refuse?
That I have never seen a scenario where they've already agreed in writing to something and then they refuse, because to me that becomes a legal matter at that point. Typically, if there was an agreement that they were splitting all of the HOA miscellaneous fees, for example, all those are being split half and half. They're splitting title fees. They're paying off a solar panel. They're providing a home warranty that this is seller paid. All those things, if those are agreed to, and then at closing, we're at the closing table, and then now it didn't make it to the settlement, and the seller is refusing at that point, then that's where, we're probably advising that our clients get their legal advice and perhaps getting an attorney involved, because that's really beyond our scope. If it was agreed to, and normally it is agreed to already, so we're just verifying that it's there, because often it's really honestly just a mistake. It was missed, And
But
I
if you
have
get
had,
if you get the settlement statement ahead of time, which is what we're trying to do, if you get it ahead of time, you can look at it and try and resolve those issues before you get to closing,
yeah.
which would make sense to go back to the original way it's written, not to
Mhm.
change it.
And I think probably all of us practitioners have been in a scenario where things were missed on the settlement and we had to make corrections. And I can't imagine having to do that after the fact.
So this isn't like 5.3 in the listing contract. If you would just like to go back to the original language, I think you can do that and we could end this.
That'd
my
be great.
I would have loved to have known that like 30 minutes ago.
It was a 30-minute discussion that's lulled us into this point.
Yes, we would love to. Well, I don't know. I can't say we. I would love to go back to the original. I
Yes.
thought we couldn't.
I
Okay.
agree with you. Go back to the original. But you still end up dealing with the title companies that don't want to give it to you. So now, if it's
And I think we
original-
deal with that on a case by case, But
Okay, so does someone want to make a motion regarding the forms?
Yes. I motion to accept the closing instructions as presented with the following corrections.
Are you doing all the forms or just the
Are we
closing?
doing all the forms?
Yeah.
Or one? I thought we had to do each one. I'm sorry.
So you already approved the manufactured home addendum.
Right.
So that
we've
one
got
is
the
marked off
listing
your list.
contracts.
Yeah, you need to
individual
make a decision about the listing contracts and then the closing instructions, which you can do them separately since it didn't sound like you had any revisions to make to the listing contracts. It's just the closing instructions where you need to make a motion that instructs us to revert or to not change the language in section 18.
Okay, Erica, you want to do the closing instructions then?
Okay. Motion to accept the closing instructions as presented with you said it so eloquently a minute ago, with
retaining original language.
Retaining the original language in section 18.
Okay, anybody have second?
Second.
All right, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes. All right, now we need to make a motion for the listing contracts. And I think we could do them all together unless somebody has something specific about one.
So I'll move to approve and accept revisions as reviewed for the exclusive right to lease listing contract, exclusive tenant listing contract, exclusive right to buy listing contract, and exclusive right to sell listing contract.
Okay, is there a second?
Second.
Okay, any further discussion? Okay, all those in favor?
Aye.
Aye.
All those opposed? Aye. No, motion passes. Okay. All right, so now we are on to complaint investigation audits.
Good afternoon. Investigative matter A is complaint number 2025-1118. On May 23rd, 2025, the respondent was convicted of burglary 1, assault menace, a class 3 felony, and assault 3, no reckless cause injury, a class 1 misdemeanor. The respondent was ordered to complete a 3-year deferred sentence for count 1. The deferred sentence is ongoing and will be reviewed on May 23rd, 2028. The respondent was also ordered to pay $2,296.50 in court costs and fines and complete 3 years of supervised probation. The fine has been paid and this matter was self-reported to the division as required. Possible violations include 1210-217-1N, conviction plea to specified crimes. And disciplinary recommendations are diversion, a $250 fine, and probation to run concurrent with the criminal sentence. And Investigator Martinez can answer any questions that you may have.
Okay, is there any discussion on matter A? Would someone like to make a motion?
Motion to accept the disciplinary recommendation as presented on license matter A. I mean, complaint matter A.
Second.
Second. Okay, any further discussion? All right, all those in favor?
Aye.
Aye.
Any opposed? Okay, matter passes.
Investigative matter B is complaint number 2024-2298. The complainant, who was the buyer, alleged that the respondent, who was the listing broker, represented in both the MLS listing sheet and a marketing flyer that a 1-year home warranty was to be included in the sale of the property. However, that warranty was never provided. Several months after the closing, when the complainant attempted to use the warranty, the home warranty company informed her that no such policy had been purchased by the respondent. The investigation found that the home warranty was not purchased, contrary to the representations made in the property's advertising. Possible violations include 1210-217-1C, deliberate misrepresentation, false promise, 1210-217-1Q, unworthy incompetence practice, and disciplinary recommendations are coursework and ethics, diversion, and a fine of $1,000. And Investigator Peters can help answer any questions.
Okay, any discussion? All right, would someone like to make a motion?
Motion to approve the disciplinary recommendations on matter B, as presented on matter B.
Second.
Okay, any further discussion? All right, all those in favor?
Aye.
Any opposed? Okay, matter passes.
Investigative matter C is complaint number 2025-157. The complainant, who was the respondent's employing broker, alleges that the respondent was representing himself in several real estate transactions unbeknown to him. The complainant alleged that the respondent failed to provide the brokerage firm with his transaction documents. Further, the respondent failed to establish a brokerage relationship. In addition to substantiating the allegations, the investigation further discovered violations listed below. I do have an update on this one as well. The complainant let us know just yesterday that the respondent reached out to him on Friday, October 3rd, 2025, asking for a commission disbursement agreement for a transaction that he closed on September 26th of 2025. His license has been inactive since August 27th of 2025. And our system shows that he reactivated his license to active status on Friday the 3rd with a new brokerage firm. And then possible violations include 1210-4082B, brokerage disclosures, 1210-217-1M, violation of any commission rule or part 4, 1210-217-1C, deliberate misrepresentation, false promise, 1210-217-1Q, unworthy incompetent practice, 1210-4091A, duration of relationship, Rule 5.21, production of documents and records, Rule 6.2, competency, Rule 6.6, brokerage relationships, Rule 6.14C, listing must be in writing, and Rule 6.14D, listings must have a termination date, and Rule 6.17B, duty to disclose conflict of interest and license status, and Rule 6.20, transaction file requirements. Disciplinary recommendations are public censure, a final agency order, revocation, and a fine of $27,500 or maximum fine. And Investigator Gabarty can help answer any questions.
Okay, is there any discussion on this one?
I don't mind discussing just because I think when we're looking at revocation, we should spend a little time because that's someone's livelihood. But my notes just said, kind of pointed to the fact that he was dismissed by 2 brokerages for pretty much the same reason. He doesn't feel that he needs to disclose his license status. He thought that the transaction broker's responsibility was to prepare his documents, that are required to be prepared by a licensee. He was asking transaction coordinators to create docs after the fact, and he even asked a new brokerage to backdate docs. So with all of that, I felt that the discipline was sufficient.
I will add, my note that I put to myself was, it didn't look like he took any responsibility for any of it, and he pretty much blamed the TC for it. And I put, seems like he was deceptive to the managing broker.
Okay.
So I felt like it was same. Stick with the disciplinary action.
All right, would someone like to make a motion?
A motion to accept the disciplinary recommendations as presented for matter number C.
We have a second.
Second.
I'll second.
All right, any further discussion? All right, all those in favor?
Aye.
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 Any opposed? Okay, matter passes.
All right, good afternoon, commissioners. Your next matter is investigative matter D. This is audit number X 2025-33. The respondent is an employing broker of a small brokerage firm performing sales transactions and property management. The respondent does not maintain fiduciary trust accounts and does not complete reconciliations. The respondent continued to perform real estate activities during a 9-week period when the respondent's license was inactive. The respondent's sales and property management transaction files lacked required disclosures, addenda, and other necessary forms, which the respondent confirmed they had not provided to their clients. Possible violations include 12-10-2171H, 12-10-2171K, 12-10-2171M, Rules 5.2, 5.14, 5.22, 6.5, 6.9, 6.20, and 6.26. And recommended discipline action includes a final agency order, public censure, a $7,500 fine, coursework in brokerage relationships, coursework in brokerage administration, coursework in contracts, coursework in trust accounts, coursework in property management, and a follow-up audit within 3 months. And myself and Auditor Jay McLean are here to answer any questions you may have.
All right, any discussion? Okay, would someone like to make a motion?
I'll move to accept staff recommendation on matter D.
Would have a second?
Second.
Okay, any further discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Okay, matter passes.
Your next item is matter E. This is complaint number 2024-2148. On December 4, 2024, the division received this complaint stating the respondent, acting as a listing agent, misrepresented the listing and failed to provide a structural report related to the property. The investigation found that the respondent did provide the structural report to the complainant, but not until after the contract had been executed. The respondent acknowledges he should have asked the seller to update the seller's property disclosure after learning of the structural issues. Additionally, the respondent delayed updating the listing to reflect the property as under contract or pending because the seller directed the respondent not to update the listing because they believed the buyer was not going to actually proceed with the transaction. Although the respondent provided the structural report to the complainant, the respondent did not provide the complainant with a copy of the associated structural estimate that the respondent had in their possession. However, the complainant was able to obtain a copy of the estimate directly from the contractor. Lastly, the respondent acknowledged that the initial listing description may have inadvertently misrepresented the rentability of the ADU. However, the complainant was informed and made aware of the current ADU information before an offer to purchase the property was ever submitted. Possible violations include 12-10-2171Q and Rule 6.10.c. And recommended discipline action includes diversion, a $1,000 fine, and Investigator Marcy Rivera is here to answer any questions you may have.
I just had a question because I felt like he probably needed a little bit of coursework in ethics. I'm just wondering if that was a sentiment you agree with. I don't see you in here. Marcy, right? Is Marcy in?
I'm here, Erica.
Oh, there you are. I see it now.
And if the commission feels that, coursework should be added to the disciplinary action, that's definitely something y'all can do.
I think so. He definitely had multiple misrepresentations, which a couple of them seemed intentional. And, just the lack of disclosure, I think he probably should take an ethics course.
I would agree with that, Erica. It seemed like he wasn't operating in good faith.
Okay, does someone want to make a motion?
But commissioners, I'm sorry, before you make a motion, Mr. Rose, I think we need to add M. It's just procedural statute that allows us to discipline for a rule. So we just need a violation of 217(1)M in order to connect 6.10C.
Done.
So I'll move to approve staff recommendation with the addition of 217M and adding coursework in ethics.
Do we need to say how many hours? Do we need to specify 3 hours? Or
I
just
think it's a 4-hour course. It's not, I believe, isn't it?
no,
That
it's
is
3.
that is what we typically ask for, is the 4 hours in ethics.
You made a motion and I'm going to second the motion if it hasn't already been seconded.
Okay, any further discussion? Okay, all those in favor?
Aye.
Aye.
Any opposed? All right, motion passes.
All right, commissioners, we are on to complaint matter F, and that is audit number X202565. And complaint matter F and complaint matter G are related. Complaint matter F is the employing broker. G is the corresponding brokerage. The complainant filed a complaint on March 13th, 2025, along with a correlating lawsuit in Denver County Court alleging that the respondent had wrongfully kept funds sent to the brokerage after the management agreement had been terminated. The lawsuit was settled with funds returned to the complainant, but requested information related to the lawsuit was not provided. A corresponding audit and review of submitted documents indicated that the brokerage held one account holding over $500,000 of owner and tenant funds in one non-fiduciary account. Reconciliations were insufficient or not reconciling. Property management agreements did not appear to comply with the provisions of Rule 7.1, the Brokerage Duties Addendum. Broker's disclosure to tenant and radon brochure were not being provided as required. A non-licensed business development manager was allowed to sign transaction documents. Markups were not being disclosed. Sales file documents were not retained or submitted as requested. And both the correction items requested within the correction letter and subpoena went without a response. The respondent did not update their address in the e-license system and was engaging in real estate activity with an inactive license. Possible violations include 1210.217.1H, 1210.217.1M, 1210-217-1Q, 1210-217-1B, 1210-217-R, 1210-211, and rules 5.1, 5.2, 5.5, 5.14, 6.1, 5.21, Rule 6.2, 6.3, 6.5, 6.20, 6.25, 6.26, 7.1, and 3.9. Disciplinary recommendation includes a final agency order, public censure, revocation, and a fine of $47,500 or max fines. And Investigator Meredith is here to answer your questions. And Investigator Meredith also has an update on this file from just yesterday.
Good afternoon. Oh, sorry. Good afternoon, Commissioners. I would like to offer an update. Yesterday, we did receive the attorney letter representing the broker. There's been no response on the actual complaint against the brokerage itself, but on the broker, they also did reply, and they provided some of the documents requested in the subpoena. They included the corrections that they had sent in May. They have not provided any evidence of correction. They sent the same folder that the commission already has as exhibited. They did submit documentation on the settlement, and the broker did pay $9,000 to the complainant based on the fees of the tenant that were missent to the brokerage. I was able to see that they do have E&O coverage now that just restarted in September. I can confirm the amount of the coverage complies, but there is no deductible that is listed. They also provided, as requested, the tenant directory and owner directory, but I have no further information, and there is no evidence of compliance at this point. Otherwise.
Okay, thanks, Betsy. Anyone have any questions?
Well, that answered my question that I had pre-prepared, which is, has she responded to the subpoena? But it sounds like most of the accounts are still out of order.
Correct. They only sent the same
folder, which I think they referenced in here, right?
Correct.
They
sent the same documents. Correct.
Okay. And my notes also just, again, this is recommendation for revocation, so I always just want to go a little deeper on something like that when you are talking about someone's livelihood. So, but my notes is that there's a number of things that she did that could potentially cause harm to the public, like not having fiduciary accounts and not providing proper disclosures and having unlicensed people prepare documents. But I think what was more pressing is the fact that she became unresponsive for a period of time, which to me signals inability to be disciplined. So that was really kind of the main concern, is just that there appeared to be a big gap of her not responding to the subpoena. And to find out that she did it the day before is just, disappointing that it took so long and it's so incomplete. So I actually agree, based on those things, agree with the disciplinary recommendations.
Okay, anyone else have comments? All right, Erica, did you want to make a motion?
Sure. Motion to accept the staff recommendation as presented.
Okay, do we have a second?
F.
I'm sorry, who's second? Autumn,
I'll second.
Okay, all right.
I don't know if anybody seconded, so
Okay.
I was
Okay.
tie.
All right, any further discussion? All right, all those in favor?
Aye.
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 Any opposed? Motion passes.
And as I mentioned, complaint matter G is the corresponding complaint investigation number 2025453. This is the brokerage in the same issue. I'll read through the possible violations and disciplinary recommendations, though. Possible violations for this matter include 1210-217-1H, 1210-217-1M, 1210-217-1Q, 1210-217-1B, 1210-217-4, 1210-211, as well as rules 5.1, 5.2, 5.5, 5.14, 6.1, rule 5.21, 6.2, 6.3, 6.5, 6.20, 6.25, 6.26, 7.1, and 3.9. Disciplinary recommendation includes final agency order, public censure, revocation, and a fine in the amount of $47,500 or max fines. And again, Investigator Meredith is here to answer any questions you have.
I did note one question on this, and in regard to the fine, because the fines are identical on both cases, are those collective fines or separate for each case?
These are separate. I'm not sure how this would be addressed in the settlement and any potential litigation, but they're being presented as separate fines for separate entities and separate investigations.
Okay, thank you.
Okay, any further discussion? Okay, if not, would someone like to make a motion?
I will. Motion to accept staff recommendation as presented.
Okay, anyone, I need a second.
Second.
All right, any further discussion? All right, all those in favor?
Aye.
Aye.
Okay. Any opposed? Okay, motion passes.
Okay. Complaint matter H is audit number X2024-124. This was a routine audit opened on the broker who made numerous corrections during the course of the audit. The only outstanding issue at the conclusion of the audit was unexplained negative ledger balances that continued to appear on owner statements without adequate explanation. Possible violation includes 1210-217 1I, 1210-217 1M, and Rule 5.14. And disciplinary recommendation is diversion, fine in the amount of $750, coursework and trust accounts, and 2 follow-up audits within 1 year of the executed stipulation. And the other thing that I would request of the commission related to this complaint and the following unrelated complaint in investigation matter I, you'll note that there was reference to in both investigations to a eviction protection plan.
Yep.
And we were asking the commission to weigh in on these respective complaints as to the commission's thoughts and any concerns related to this industry practice of an eviction protection plan. And you may recall that approximately a year ago, a investigation was brought before the commission. A eviction protection plan was discussed and was part of that investigation. And as part of the response from the respondent, they had agreed to terminate the plan. And that was a voluntary termination agreement to terminate. However, it became part of the corresponding stipulation. In these 2 cases, there has not been any voluntary agreement to get rid of the plan or to cease practice related to an eviction protection plan. So we would like the commission again to weigh in on the appropriateness or concerns of these plans and then provide direction to investigators and auditors as how you would like us to approach these in the future when conducting audits or investigations. And Investigator Meredith is here to answer your questions.
Okay, discussion?
I had some notes on that plan. Because I do remember we had that about a year ago. And I don't know that we addressed it in great detail back then, but I can see the benefit to a landlord who is not familiar with that process, who wants someone to handle that for them, who doesn't necessarily want to get their attorney involved, up to a point if it can be handled for them in a cost-effective manner. I understand that the company, the property management company, is going to make money on it. I don't have a problem with companies making money if they're offering a service that is helping their landlords in these situations. So I did have some questions like why, you know, if it's being operated well, if they're doing what they say they're going to do, because it's going to fluctuate. I know that in this case or the other one, it wasn't utilized frequently in this particular one, but next year it might be utilized a lot. And so there's going to be a wave as to whether they're either making money or they're not, or it's a enormous benefit. I don't know. I had a lot of curiosity about this particular program and why it might not be an appropriate offering. Maybe you can answer some of that for me.
You're directing that question at me?
Sure.
Okay, so I just want to make sure I don't want to step on toes. So I think there's a couple of concerns here. First is it disclosed? I mean, if it's fully disclosed, that's one thing versus the other case where it doesn't appear to be disclosed at all. That would be the first layer. The second concern is there are states that have banned these because they mirror insurance, basically. And then that's, you know, whether or not the money that is being made under the guise or under, you know, the umbrella of paying for evictions, but in reality, it's really being paid to offset other brokerage expenses versus, you know, being held aside for evictions. Another question that came up is if they're collecting this money, does it technically belong to others? Does it need to be in a trust account? But I think the biggest concern has been is that it mirrors insurance, and so that's why we were seeking your guidance. And of course, there's a difference between it being fully disclosed and not being disclosed at all.
Since I'm newer to the board, I haven't really seen too much of this eviction protection plan, so I'd like us to go over that a little bit more. I don't know if it needs to be added to the next agenda for us to go over more. But when you're saying it sounds like it mirrors image, the first thing I think of is licensing to sell insurance products. If it is kind of presented as like an insurance type product, should they be licensed for it would be my first question on that. But I don't know a lot about the eviction protection plans.
And commissioners, if I could just weigh in there, we have had discussions about potential issues and what could be problematic with the plan. And that did include discussions about whether or not the practice should be viewed as more of an insurance plan. Ultimately, we would defer to the Division of Insurance as a regulatory body to determine whether or not they have concerns about that, and they have not yet done so. But some of the other concerns, as Investigator Meredith indicated, included whether or not these funds should be in a trust account. If they are designated for a specific purpose, is it appropriate for them to be used to offset other brokerage costs? And you may decide that that is or is not appropriate, but those are some of the discussions we've had internally.
I mean, I wouldn't think that they would need to be held separately because it is a piece of their income that they're earning. And as long as they're taking care of when something like that happens, as long as they are taking them through that process, I mean, it's a line item income piece for them and offering part of that service. In this particular one too, they're waiving like repairs and fees if they opt into the program, like a $350 reserves. But also I could see how it sounds like they're all offering something different. Like there's not an across the board type offering. So it's somewhat hard to compare one's offering with another's offering, which makes it a little different. You do kind of have to take that on a case by case. But as long as they're taking care of when it happens, I can't imagine why, well, I can imagine, but I don't know why you would have to keep that into a reserve for them, because you might not have enough in there when you need it. If it's in a reserve at $25 a month and you have a lot of different people that you're having to do evictions, you're still going to have to add money to that to get them in that next year. And then the following year, you won't have any evictions that you're going to need. I just don't know how that it would make sense to have that into a trust account. They just have to.
I think that makes it sound like it is an insurance product, because you don't know until you need it. And then what happens if they're paying into this and all of a sudden they don't have the money, the supplier doesn't have the money to pay all this, or if there's multiple, when you're looking at, let's say you have somebody that's doing multiple of these and they have multiple evictions at once and it's costing a lot more money and they can't, then I think it just sounds, that right there makes me think of insurance.
Yeah, it definitely sounds like insurance. And I know I've had clients that have made decisions to utilize programs similar, to this. What stood out to me was the amount that they were receiving versus the amount that they actually utilize. I mean, it was a lot, right? It's like they were making, pretty good money on this. I think in terms of direction, because it does have a big insurance feel to it, at some point it probably should go to the insurance division just for some kind of guidance, as if to see if it is under that category. But for our purposes, I kind of feel like it's going to be a case by case thing. Back to what Betsy said, was it disclosed? Right now, it doesn't seem to be illegal to do it. So I don't know that we can do anything at this point, but I do think it's something that should be on the radar. And I surely think that we should take it case by case. Certainly, if it's not being disclosed, and because a good point was brought up. It was one I was thinking of too, is, if you have a circumstance where that $25 that they're paying monthly doesn't cover it, and they've expended their resources on other people, and then now what? Right? That could be a big problem. So I guess that's where I guess I think if there's any way to start conversations with the Division of Insurance, we should. And then from there, if it's not in that category, we probably should start to have conversations around it. But I think right now it doesn't seem that it's illegal. We all can see where we could have problems, however, as a result of it.
The case that occurred previously had lots of other issues. It wasn't straightforward. It was a different type of case. And this, in this specific one, and they did disclose it. They did talk about how much per month. It is straightforward that they are waiving the $350 eviction fee. There's a limit to $1,000 over 12 months. So everything is disclosed. It is optional. I don't think it needs to go into a trust account. As Erica said, that this is another source of income for the company. And if it's not like you're not paying out $5,000, you're paying out what the limit is. In this case, on this one, the limit was $1,000. Everybody has different limits and different things that they're going to cover. So I'm not sure that it would fall under the insurance category. But I don't think it needs to be in a trust account, because it is going to the company. And then they have, like I said, it's spelled out in the contract what they're getting for it. This one was very specific. I didn't see anything wrong with what they were doing in this case. The case before was different, but this one looks good. It's put together well and it's straightforward.
And then just bringing the conversation back, unless someone else has anything outside of that, I'm happy to make a motion in regard to the issue. If no one else had any issues or concerns with it, I felt that the discipline was appropriate.
Okay, you want to make a motion?
Yes. Motion to accept staff recommendation as presented for matter H.
We have a second?
Second.
All right, any further discussion? All right, all those in favor?
Aye.
Aye.
Bye.
All right, any opposed? Okay, motion passes.
Thank you, commissioners. We appreciate that discussion and the direction, and we will apply it moving forward. All right, moving on to complaint matter I, and that is audit number X2025-15. A routine audit was opened on the respondent on February 10th, 2025. Despite a correction letter, a final notice to comply, and substantial time given for corrections, it appears the following items remain out of compliance. The broker has not been able to provide a compliant reconciliation for either the rent or security deposit trust account. Fees charged to owners do not appear to be agreed to in writing. Adequate disclosures of the conflict of interest of the maintenance company. Though disclosure appears on the website, no evidence was provided that owners were aware of the conflict. It appears that the brokerage is utilizing DBAs that are not registered with the division, and standard forms have not been adequately updated to comply with the provisions within Rule 7.1. Possible violations include 1210-217-1H, 1210-217-1M, 1210-217-1Q, as well as Rules 5.14, 6.10, 6.17, and 7.1. Disciplinary recommendation includes diversion, a fine in the amount of $2,500, coursework and trust accounts, and 2 audits within a year, the first to begin no sooner than 90 days. And Investigator Meredith is here to answer your questions.
So going back to the eviction protection, in this case, it was a little bit different. It was not as clearly defined in the PMA. And so this one, I think, could have more of an issue because it wasn't, full disclosure, et cetera. So I know you said we're looking at last case. In this case for that, this one I see more issues with because of how the lack of disclosure and presentation.
I had that same thing written down about the EPP plan on this one, that it was just not fully disclosed. And so that does need to be very clearly defined for people if they are working with this program. Not a clear agreement for markups. Seem to be confused on the DBAs. Reconciliation. So I think I'm okay with the recommendations.
Would we want to add an ethics course?
I would say
17M
yes.
is on there.
Because with the coursework, what was the coursework? What was the coursework that was recommended?
Trust
Record
accounts.
keeping. Yeah,
Yes,
record
trust-
keeping. Oops, sorry, go ahead.
Trust accounts.
Oh, yes, I'm sorry. I was looking at the wrong spot. Yes, that's all it was trust accounts.
So then I would say add ethics to it too. You can't do any predatory. To me, I look at that if they're not giving enough information about that product, that's a little predatory, and just adding money to themselves, and they're making money. on the banking side, I would look at that and say that's predatory. And so I would think that should require some ethics training on that.
I was also debating whether the fine should be increased due to the number of things that were forms that were missing and verbiage that was wrong. There are just so many items on this. I would be open to increasing the fine.
What were you thinking, Renee?
What did we say the current fine was? 7,500?
25.
25.
25.
Yeah, so not sure if
Wow.
anybody has an
Yeah.
idea how much.
I mean, I'm open to the thoughts and opinions that you have, that you both have. My notes were initially to agree with the proposed discipline, but especially Renee, you being in that field, you know, you may have a better scope of it than I do. So I'm open if you guys want to just kind of, I know ethics was mentioned, and then what fine are you thinking?
I would increase it to at least 4,000.
Is anyone opposed to that?
No, I'd agree with that.
Okay. So I'll move to accept staff recommendations with 2 modification, the addition of coursework ethics, 4-hour course, and the increase of fine from 2,500 to 4,000.
Okay, do we have a second?
Second.
All right, any further discussion? All right, all those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes.
All right, and then complaint matter J is audit number 2025-66. Though the broker made substantial corrections throughout the course of the audit, despite a correction with extensions and final notice to comply, the broker's property management forms are not fully compliant to include the relevant 7.1B disclosures for the attorney drafted forms. Possible violation includes 1210-217-1M and Rule 7.1. Disciplinary recommendation is diversion, a fine of $500, and a follow-up audit to include only review of the property management forms. And Investigator Meredith is here for your questions.
I have a comment on this case. The thing that kind of concerned me about this is when we talk about the standard forms and the violations there, this case referenced the fact that the attorneys did prepare the forms and perhaps the attorneys didn't make the disclosure. So I give pause to the idea of disciplining her when she was likely seeking her attorney's advice and under the impression that the attorney gave her proper guidance in terms of how those disclosures should be listed on the form. So I'm a little concerned about that piece. My notes said, I don't know, maybe we should and forgive me because I don't recall, because we don't use it often, this tool, but I know there was like a letter that you could send saying, look, you did something bad, we're watching, don't do it again. And I was leaning more towards something like that with an audit, because it just didn't seem right that we're disciplining her when her attorneys at least gave her an impression that she was in compliance. And if I misunderstood what I read, please, correct me, but that is how I interpreted this particular case. So did I misread? Did I misunderstand that the attorneys actually didn't provide the disclosures, although they provided her with the forms?
Correct. That is the main issue. I think the one thing that Commission can weigh in here is the broker is ultimately the one responsible to make sure and follow up that their documents comply. And this was with several notifications. But to your point, this is something that you get to weigh in on, but your assessment is accurate.
Yeah.
I
Can someone tell me what that letter is? Do you know what I'm talking about?
Yeah, the letter of concern.
Thank you.
There was something else on there too that there was like a package of forms or an addendum, and I think they said something about how the notice was on part of them, but then it didn't make it through onto all of them. I don't know if I'm recalling all of them.
you're
Right.
Correct.
Yeah. So I agree with you, Erica. I feel like she thought she had done that accurately and had double checked to make sure she got it correct through 2 attorneys' offices. And then there was reference that we both do these the same way, but it kind of, she got caught in the middle of that, which was somewhat unfortunate. So I fully agree with that. I feel like she
And
was.
one attorney said that from his perspective, when there's a package like that of disclosures, when you disclose it on one, from his perspective, you don't need it on all the others. So I just think that we're getting into slippery territory when we're trying to have a broker go against an attorney that understands law. We're always going to take our attorney's advice, and we're told to do that. And then when you do it and then they're wrong, now you get disciplined. I think that's unfair. So I think a letter of concern would be more appropriate, just to say, hey, you did this wrong, but it's giving, now she's on notice, and then do a follow-up audit. But I wouldn't even, personally, I don't even recommend a fine or anything in this particular situation, because I just think it's unfair. I think
Now, I want the opposite way. I thought the fine should be increased and she should have coursework. The attorneys who prepared these forms know what they're doing. And there was some question in my mind because there were so many different firms preparing these. You have to have your forms, you need to have your forms looked at very often with all the legislative changes that are going on. So this looked a little funny to me, that you would have all these different firms looking at your PMAs and leases, et cetera. So there were multiple things that were wrong. When you looked at these, I know she fixed the fiduciary accounts, but there were other issues on some of the forms, and the forms that are, I'm sorry, the attorneys that are drafting it, these attorneys know what they're doing. So something is fishy or looks fishy to me in here. So I was going to say an increase in fine and coursework in leases and in legislative updates.
Is it accurate, and this is to the investigators, Betsy and anyone else that can chime in.
Sure.
Is it accurate to say, because what I recall reading in the investigation was that, I could clearly remember one particular attorney who, yeah, I mean, I know would be very knowledgeable, but that attorney actually said that they were under the impression that those things were disclosed, that because they put it on one, it covered all of them. And that's part of her discipline.
Well, and to your point, part of the challenge, and as I mentioned in the report, is that there was 2 separate leases, one from one attorney, one from the other, and these documents were going back and forth. So we really don't know which attorney drafted those, because they were using them, she was using them interchangeably. And so they weren't the exact same, packet. And so it was unclear who actually drafted those, where did they come from? So that's the answer to that.
Well, one of their names was spelled wrong, and I'm sorry, if an attorney drafted this, they could spell their name correctly. I am positive. And there's one of these forms in here where the attorney's name is really spelled incorrectly, and that raises a big red flag.
And I didn't catch that, so good catch.
Yeah, I can show you where it is. It cracked me up. I'm like, really? I don't think the attorney would misspell their name. So that's why it raises multiple red flags that there are so many different forms, different types. They don't look the same. There's different attorneys, different names. Somebody's name is spelled wrong. So that's why I thought the fine should be increased, and then we should add additional coursework. And this person needs to go get all of their forms, looked at by an attorney and done properly.
I'm with you on that, Renee. I put that she needs to finish complying with the audit requests. It looks like there was some miscommunication even between documents. And I put something doesn't look right. This is what I put to myself on this.
Yeah. So right now the fine is only at $500, which is nothing. Even if we doubled it to 1,000, that would be better. And then I would recommend adding coursework, like I said, in leases and legislative updates. There's clearly some disconnect going on here. So I think education should be part of the solution.
Yeah, I think they need to have their documents looked at too. So they have like some standard forms that they use across the board. Because then you're putting too many things mixed in there. She is, and it's confusing.
Yeah. So anybody else have any discussion?
If I could, I just wanted to add a little clarification to a question that Commissioner Sanders, you had asked about a particular letter. And just in your license, in your Practice Act, you have what's known as a letter of admonition. And that's something that's used when there is a violation that's been identified, but you don't think it warrants formal action. One of the little problems with that letter is that it is appealable. So you could issue that and then the party could appeal that. And then we've got, ongoing litigation. The letter that Investigator Meredith mentioned, a letter of concern, isn't really spelled out in the Practice Act, but that's essentially a dismissal with just saying, here's the things we were concerned about, but it is a dismissal. And so in those circumstances, in the two letters, we don't have the option to require then any other term. And so if you wanted to require coursework or fine or audit or any terms, that would have to be done through a stipulation. So I hope that's helpful just to lay out what some of your options are.
So like the audit would not be possible with that one.
The commission has the ability to audit without, an agreed upon document because it's in your Practice Act. But if you were wanting to have a follow-up audit required within a certain amount of time, that would best be done through a stipulation where the parties agree to that. We would not put that in a dismissal letter, which is the letter of concern that Ms. Meredith mentioned.
Thank you for clarifying, Penny.
Sure.
I'm just reviewing some of the comments from the attorney.
So do we have more discussion, or Bernadette, do you want to make a motion?
Before you make the motion, I'm still not personally not completely on board with some of the other things that were brought forward, like increasing the fees. I mean, obviously I wanted the letter. I think I'd probably have to scale that back down to what was presented. So I just wanted to just make that position known, but I'll vote accordingly, so you could still make your motion. I just wanted to just mention that.
Okay, does anybody have further discussion or someone want to make a motion?
So it would be, now bear with me on this one. Motion to
You would say motion to approve with the following changes, if you want
Okay,
changes.
motion to approve with the following changes. Increase of fine to $1,000. We had 2 audits, right?
It just says one follow-up audit. But we had talked about maybe doing coursework. I don't know if you wanted coursework or
Yeah.
not.
Well, yeah, so adding coursework in the 2 for the coursework was
So leases,
contracts.
leases could be contracts, but it could leases and legislative updates.
Leases and legislative updates. And then with the diversion, right? That's already part of that.
Yes.
So I think it was just adding those.
Correct.
Okay, if that wasn't messed up.
That's okay. We got it. So the motion is to approve staff recommendation with the changes of increasing the fine to $1,000 and adding coursework in leases and legislative updates.
Yes.
All right. Okay. And does anyone want a second? Okay, I'll second. Any further discussion? All right, all those in favor?
Aye.
Aye.
Aye. Any opposed?
Nay.
Okay. So motion passes.
Have a good afternoon, commissioners. Thank you.
Thanks.
Yeah.
Okay. Moving on to complaint number K, that's number 2025-194. The complainant alleged the respondent deliberately misrepresented the overall square footage of the property she listed in the MLS. The respondent denied the allegation, stating the square footage used in the MLS was based on architectural plans. The investigation determined that during the listing, a company hired by the respondent measured the property and calculated a square footage amount less than the advertised amount. This information was not relayed to the subsequent buyer/complainant. And this is another one that we are bringing to you for your direction based on discussion of the underlying circumstances. We typically have not identified a violation on the part of a listing broker for advertising what turned out to be an inaccurate square footage amount, provided they identify the source and that there is a legitimate source that was used in their advertisement. In this particular case, it's a little bit different because after the property was listed, there was a subsequent company that was hired to perform the square footage, and then the results of their measurement were provided to the respondent, and it indicated that the square footage of the property was approximately 500 square feet less than what had originally been advertised. And so part of our question is, does the respondent at that point have an obligation to disclose that information to the buyer? And then also included with that was the subsequent request by the respondent to take the square footage off of the marketing materials that were provided by that company that did the measurement of the property. So we've identified potential violations, which could include 1210-217-1C or 1210-217-1M and 1210-404-3A. But we're requesting your guidance as to whether or not you feel if any of those potential violations actually apply in this situation, and you may find that they don't. And then what you feel a subsequent disciplinary recommendation, what would be an appropriate disciplinary recommendation if you feel that a violation actually occurred. And Investigator Walker is not here to answer your questions, but I will attempt to do so if you have any.
Well,
I'll jump out there on this one. Or no, go ahead. Sorry.
Oh, no, that's okay. You could go ahead. Go ahead.
I mean, I feel like there was a violation on this one for sure. I know that a lot of MLSs, you have one profile that you can put out there for your square footage. So I can understand that you have, that's what you have to start with. That being said, you have confidential remarks that you could put that in. You could have public remarks that you could put the discrepancy in. Then you have your square footage disclosure that you should be putting on there. Here's the measurement that we have. No, seller gave it to us, plans, whatever. Here's another part where you can put your assessor record. It also varies from this. Then we had a third party where it says other, and you could lay in there, well, we had it measured by this third party, and it has another one. There are so many different areas to disclose this, and just saying, well, the buyer's supposed to find out on his own that this is wrong is, in my opinion, not at all the way this should have gone. And I know that the seller, as I read through it, the agent was pressured by the seller, and I'm just reading through this a little bit. Is it accurate that the seller was also a managing broker of another real estate firm? Put pressure on this respondent to not use her measured numbers, but that's when you've got to be able to say hard stop here, like absolutely not. We can provide your numbers that you have, but we need to address these other ones that we have. So I feel like, yes, there was very much a violation, and there were a lot of different ways that could have been disclosed. And then she wouldn't have had a violation at all, because you have the information out there and you're like, we can fully verify this, but we just want to give you all of the details. And it was just a big problem. So those were my comments.
Now it's also
And I totally agree with that's along the same lines that I was gonna say, which is, to me, she seemed to misrepresent the square footage. I'll add that not only was her client a broker, but he was an attorney, which is even more insane. But if I recall correctly, unless I'm mixing things up, but I'm pretty sure. That being said, I think that for all the reasons Erica just mentioned, the fact that it could, if it was disclosed in writing, simply, hey, we have 3 different variations of square footage, we don't really know which one is right. If that had been like clearly disclosed, I think that she would have a pass, because at least she said this one said this one said that, this one said that. So it's hard to determine who is right when you have 3 different opinions. That being said, I think that there was some misrepresentation, so I think that is a valid statute violation. I think that there was a failure to disclose a material fact, because if nothing else, when she received that information, that should have prompted her to at least add that to her square footage disclosures. And then lastly, if those 2 are considered violations, then she would, then of course 2171M would apply, which would mean that she violated a commission rule. So in terms of fine, that's what we can talk about, but I do think that she's in violation, but I'll let the other commissioners weigh in.
Well, the other big result is that the consumer was definitely hurt in this case. I mean, they calculated out how much it was, and we're talking lots of money. That because of the size that they thought they were buying, and then when they went to sell it, the size was different, and so they couldn't sell it for anywhere close to what they bought it for. So the consumer was immensely hurt in this situation. So I think there needs to be coursework, maybe in ethics and contracts, and the fine. I'm not sure, Erica, did you have a recommendation on the fine? Or
I'm not sure which Erica, but my notes said like about 1,500 minimum, because that's like 500 per.
Yeah, well, I was thinking more like 5,000, but this was a tremendous deal, purchase the price and everything. And this would be basically a slap on the wrist to this person for what they made on the commission. And because of the amount that they hurt the other person, I don't think 5,000 is out of line.
So I have something to add on that. The buyer, the original buyer, he chose not to do an inspection. He chose not to do an appraisal and then wanted out of the contract at the last minute. I feel like, I mean, I think of my house, and I literally have two or three different measurements of my house. I feel like she left the square footage in the drawings. I didn't know that she could say that, there's 3 different square footages. So I didn't know that part.
Square footage wasn't in the drawings. She had them take,
well, they just had the measurements. Sorry. They had the measurements in the drawings.
The rooms, but not the total square footage. She had them take it off there. So it was intent to.
I don't know. I don't know if I see it that way though. I kind of don't see it that way. I think she still left those dimensions there. I don't know. I don't feel like that sounds crazy.
She asked the company to take them off.
Point of clarification from what I recall, and maybe we could get, the investigator's not on, but from what I recall is that the square footage that she was in the county record, so that was there. On the renderings, there was square footage there. But then on the MLS service, I forget the name of that company, but the company she hired to verify the square footage and do, I'm guessing it was like the 2D, the floor plan. That's the company that she had removed the square footage because it was inconsistent. So, and it was lower. But the county square footage was there. The other drawings were there, except it didn't have the basement square footage. I just want to make that point of clarification. Correct me if I'm wrong, but that's what I recall reading.
No, the company that she had go measure it, we have it there that she was at. They said, would you be willing to remove the values of each floor, but keep the room dimensions? And she had them do that. So they did not have the total. Who's going to sit there and add up dimensions on rooms to get totals? Nobody. You're going to, it's a new construction or, it's a new build. You're going to take what they say. Who would question that? It's not something you normally would do, but she purposely had them remove the values off of each floor. So I think that there was, intent to, I hate to say defraud, but intent to, not tell the truth there by removing those things.
I don't disagree with that. I was just clarifying that the square footage was on the initial renderings, but they didn't include the basement. To really speak to Bernadette's point, it was in the initial renderings without the basement. It was in the county record, but she had them take it out of that other one that you just mentioned, Renee.
And so, but I know she is the one that called that company separate without the owner. She's the one that called to have it measured. Because the seller of the house was like, I don't need to. We don't need to do that because he had drawings. I probably would have went with the drawings that from the architect, because that's who's they have to put it all together. Everything has to go by square footage. It has to go by, when you're building that, like everything for your beams to how much you need for that, and electrical, and where all those outlets, like all of that. So I probably still would have went with the drawings, because I think that would be more accurate, even having somebody out.
But since she didn't go with that, because once you got to disclose, right? So once she knew that there was a conflict, what are your thoughts on
three different sizes, 3 different measurements? I guess, yeah, she could have said there was 3 different ones, and And, you know, they did just say fire to verify. But then I still felt like the guy didn't do an appraisal. He didn't do an inspection. He wasn't doing his due diligence either.
Yeah, but if
To
you're
buy a
paying-
house, if you're gonna spend 3.5 million on a house, why would you not get it inspected? Why would you not get an appraisal?
You don't always need an appraisal, though. If you're not doing a loan and things, there may not be a reason for
Yeah.
an appraisal. So,
I mean, are we in agreement that because she was aware of the square footage on the company that she hired to come out, like she obtained that information and didn't share it? Are we on the same page that that probably is a violation of license law?
I see where it could be seen that way. So
Look at it like this. Let's use a different scenario, but
Okay.
same outcome. Structure. You think, maybe the structure in this house it seems like maybe something's going on. I'm not sure because I haven't had anyone come in, but maybe, you're wondering. And then you now hire a structural engineer to come out who confirms that there's a structural problem, right? Now,
Mhm.
if that was undisclosed, we would feel that they withheld that information.
that
right?
was deceptive. Mhm.
It's really the same thing. It's not as major as structure, but now you've hired an expert to do something that they did, and they're giving you information that you are now not disclosing to a party. So to me, that is dishonest, right? Because you didn't
In-
disclose that.
In that instance, I would say yes, because it's the structure thing of it. I still look at it as, I would still go with what the architect said. I still would say that I would have went with the architectural square footage, because they have to have that. That has to be right.
But it could be
That has-
wrong.
plans could have changed. You
It
don't know
could
that
be
those
wrong.
were correct.
And if she
Yeah,
would have
that's
done
true.
that, I feel that, to your point, had she done that, right? She just said, we're going to go with this report. I'm going to provide this document. I'm not going to do another measurement. She just used what she had in her possession. I think she would have been fine. She took it the next step to get someone to come in, and that created
I agree.
like new line of information, which is a material fact, because if you're purchasing a house and it'd be 4,900 versus what was it, like 42, or it was a lot different.
4,944.
Before, I mean, this is a big
Yeah,
difference, right?
It was like 400 and I was almost 500
That's
square
a whole
feet.
good sized room. That's a big difference. And if someone is buying a home with the idea of this square footage in mind, and they find out it's significant, I mean, we're not even talking about 100 square feet. We're talking about, almost 500 square feet. That is a significant concern, right? And so that's just as, to me, that's just as detrimental as information about a structure. To find out the square footage is off that much. I mean, that's a big piece. But the problem I think that she created for herself is that she did get an independent, we'll call it, measurement, an independent measurement that she did not disclose or use. You know what I mean? So it's like, and in fact, she told them to take it off. Like, oh, just take the square footage off because it's, you know what I mean? And reality is it could have been accurate. We don't know. But the right thing for her to do is say, here's three. I don't really know which one is right, but here's all three for you. And if you want to measure, you have the duty to do that. But I'm going to show you all the three and give you all the three sources and let you do the due diligence.
I think she could have disclosed all three, which I didn't realize that she could put that in there, that these are the three, all the measurements. That's where I think that could be where she hurt herself with that. But I still don't think that the guy that bought the house, I don't think he did his due diligence. I don't think, as a buyer, me as the buyer, if I'm going to buy something, I'm going to make sure that, like, an inspection for sure. If I'm gonna spend 3.5 million, I'm gonna get it inspected. I don't feel like he did his due diligence in it. So, but
An
it's not
inspection,
about what the buyer did. It's about what she did.
an inspection doesn't tell you square footage.
No, it doesn't.
No, so
But-
doing an inspection isn't going to help with that. And if you don't need an appraisal, you don't need an appraisal. But so the question is, what do we do with this? We have, Garrett recommended, he had 3 violations. And Erica, I think you said for sure 1 or 2. I'm not sure what I wrote down 1, I'm not sure what it was. The 1210-2043A. What is that one?
4043A is failure to disclose adverse material facts.
404. Okay. So that's adverse facts. And then 1C and 1M. What were those?
The first one is deliberate misrepresentation, false information. So she did that.
Okay.
But she told him to take it off.
Okay.
The second one is violation of any commission rule or part 4. Real quick question. Is there a rule that she violated here? Would this apply?
The 1210-217-1M would bring in part 4, which was the failure to disclose adverse material facts.
Thank you. Okay, got it.
That's the placeholder.
I would like to
whether or not this would fall into that category of a known adverse material fact, and whether or not the measurement by the company or by the respondent, whether their measurement was accurate and then represented something that was factual and known to the respondent that they needed to disclose, that might be in question. But Commissioner Sanders, you had, I think, pointed to maybe the conflicting square footage amounts could be the adverse material fact that needed to be disclosed. Or you could potentially look at 1210-217-1Q and just say that the failure to disclose the square footage represented unworthy or incompetent practice.
Okay. So, and then remove the others, right?
No. I don't.
And that's entirely up to you. Those were presented as potential violations.
Okay.
But it's up to you if you want to use any or none of those.
Well, just to move the conversation along, because I know we could spend a long time on this. I'm gonna make a motion. Sorry, can you just tell me one more time, since I don't have my binder in front of me with all the statutes and everything. 1210-217Q, what did that state again?
That one is having demonstrated unworthiness or incompetency to act as a real estate broker by conducting business in such a manner as to endanger the interest of the public.
I'm going to
Why wouldn't we throw all 4 of these on there? Just asking. I mean, all 4 of them. Do some of them conflict? Is there something we shouldn't put on, or can we put all
some
4?
more appropriate than the others, or you may feel that they're all appropriate or none.
I think I'm gonna make a motion with just 2, and you guys can, if you have a different motion, please, add it. But I'm gonna motion that we implement by the following violations: 1210-217-1C, which is deliberate misrepresentation, false promise, and 1210-404-3A, which is failure to disclose adverse material facts, because I think we can easily prove those 2. And I recommend diversion and a fine of $1,500. That's my motion.
Commissioner, before you finalize your motion, I just want to make sure if you are putting 433A there, we have to include M because M is the connector that allows
okay.
you to discipline for part 4.
Gotcha. Okay, thank you. Sorry. So correction to add 1210-217-1M. So the 3 violations as presented in our options, and then a $1,500 fine.
And I would like to amend that. We can see what people say. I would like to make the fine 5,000, and I would like to do coursework and ethics. And I don't know if we do contracts or broker disclosures, but I think there needs to be something more in there.
I would be supportive of the 5,000. I was going to do 7,500 because I just feel like this was very intentional all the way along. And definitely ethics.
And then what coursework? I mean, I was trying to think, brokerage duties or contracts or something. I don't know, something else besides ethics or
Well,
not?
I think ethics covers most of it in this one.
Okay.
But if you have another one, that's fine.
And I'm, did you identify diversion versus final agency order or public censure?
I in my motion, I identified diversion.
Okay.
But it's been amended to, I said 1,500, it's been amended to a $5,000 fine and then ethics course so far. Right?
Yeah. So is everyone okay with that? Erica, Erica Doyle, do you want to make that motion or?
Sure. So we're leaving what we have on here as far as the statutes, then that has not changed.
Yeah, we've got the 3.
Okay. So motion to approve staff recommendations with the addition of diversion and a fine of $5,000 to Commission Matter K.
Except there weren't any staff recommendations, so.
Well, yeah, I'm looking at the violations.
Ethics.
So the violations, and we are also adding coursework and ethics.
I can amend my motion.
Okay.
So motion to impose the following violations: 1210-217-1C, 1210-217-1M, 1210-4043A. Disciplinary recommendation would be as follows: diversion plus a $5,000 fine, as well as coursework and ethics.
Okay, do we have a second?
Second.
All right, any further discussion? All right, all those in favor?
Aye.
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 Any opposed? Okay, motion passes.
All right, matter L is complaint number 2025-1995. An anonymous complaint was filed with the Division of Real Estate alleging that the respondent was, quote, loaning out his license to unlicensed persons and firms. The complaint was based on a Colorado commercial real estate listing in which the respondent was the listing agent. The listing expired on December 31st of 2024. The listing in question was co-brokered with a firm in San Diego. That firm and the 3 individuals listed with that firm on the advertised listing are not Colorado licensed brokers. The respondent provided a written response to the division stating that co-brokering with an out-of-state broker who was not licensed in Colorado was allowed, and further stated that the Colorado Division of Real Estate did not have jurisdiction over the matter. During the investigation and while trying to understand the respondent's business model, the following issues were identified: use of non-CREC forms, discharging brokerage duties for a flat fee, and failure to formally identify the brokerage relationship with the seller. Possible violations are 1210-217-1M, 1210-217-1Q, 1210-4051, Rule 7.4, 6.1, 6.2, 6.5, 7.1. The disciplinary recommendation is a final agency order, public censure, coursework in brokerage relationships, coursework in contracts, and a fine of $7,000. And Investigator Coates is here to answer any questions.
I do have a question because I don't know. When I read this, I found this, in my opinion, it was the most egregious case we had. Like when I read it, I just couldn't believe that someone was literally loaning their license. So I was just curious, why revocation wasn't on the table.
I believe, oh, Sarah?
Yep, I was just going to say, revocation can definitely be on the table if that's something you feel. It wasn't that we were against revocation. This is just what we came up with, but that's obviously for you guys to discuss. So,
okay, I was just curious because the idea of loaning your real estate license and then allowing people to utilize that from state to state. I mean, that is, to me, very problematic. Never heard of such a thing.
I will comment, if you don't mind. I think the reason why we didn't initially present revocation, not that we would be opposed to it, is that a transaction didn't happen. But that's not to say that what he was doing wasn't serious, but real estate transaction did not come to fruition.
Okay. Thank you for that clarification. When I read that, I thought, oh gosh, this is definitely going to have a revocation recommendation. And then I saw it and I was like, oh, it doesn't. And he didn't seem to feel that he was doing anything wrong.
Correct.
He was very antagonistic.
Which bothered me too, because it's like, I don't think through the end of the investigation there was ever any ownership of, oh, I didn't understand, maybe I shouldn't do that. Maybe that would have been helpful and would be easier to accept this discipline if a person takes ownership and says, I understand, maybe I shouldn't do business this way. I will cease and desist in how I'm practicing. But I didn't really get that from.
So do you have a different recommendation you would make, or
I personally thought the license should, I was surprised to see final agency. I thought it should be revoked, but I do understand the comment that there was no transaction that occurred, but I at least think we should discuss it as a body and make a decision, because I think it should be on the table, at least for discussion.
Okay,
So
anybody else?
I have a question on this. On the commercial side, isn't it pretty common to have people outside that could be outside of the state doing transactions?
Yes.
Like this, when I'm thinking like big commercial stuff.
They have to tether themselves to a broker in the state that is licensed for guidance. Oftentimes the relationship crosses state lines. So there's a little bit of sidestepping that happens at large brokerage agencies, but ultimately the person closing the deal is the broker who's licensed in the state of the transaction.
So because he was not in the state, but licensed in the state, that's where I just want to make sure I understand that, because
he was allowing people through his website to effectively use his license. So it's a little different. So, and I don't feel that it's much different in residential, right? So in residential, let's say, let's just say you, well, maybe a little different in residential. In the scenario that you gave, you're working with an agent that's licensed in another state. You're on that transaction. They're very active in the transaction. They're getting the paperwork. They're doing all of the work, right? But I mean, you're working together, but their name is on everything. They're very active. In this case, it didn't appear that that is what's happening, I could literally just go on his website and sign up for him to broker like my transaction, you know, without
he
all the
wasn't
other
doing it.
formalities that are normally in place, I guess is.
I did write that. I did write that he's advertising, and then I also said he's advertising his services and to salespeople, which salespeople are not licensed, is what that was a problem for sure. That's what I put on this. So I just wanted to make sure that I understood that right.
That's how I understood it.
Okay.
Okay, any other discussion? Does someone want to make a motion?
I mean, is anyone else, just while we're in our discussion phase, is anyone else leaning towards revocation? Is that just something I was kind
I
of
think that's hard
pondering?
since the transaction itself never took place.
Yeah.
I mean, this could be, this should be a painful slap in the hand and hopefully a valuable lessons learned.
Okay, yeah. Well,
So do you think that the staff recommendation was okay where it was, Autumn?
I'm okay with it, yes. But I to Erica's point, I think it's good to at least have that conversation about the potential about revocation. But I do appreciate the investigator Coates confirming that there was no transaction that actually took place.
Okay, so Autumn, do you want to make a motion?
I'll move to accept staff recommendation as is on matter L.
Okay, and do we have a second?
I'll second.
Okay.
I think we're getting tired.
Any further discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
All right, investigative matter M is complaint number 2024-555. The complainant explained that respondent had represented him as his broker and his accountant for a 7-year period. Complainant stated that in March of 2021, he told the respondent that he wanted to sell his property because he was moving to Texas. There was a tenant in the property at the time. The complainant alleged the respondent told him that it would be easier for her to sell the property if he signed the property over to the respondent via a quitclaim deed. In addition, the respondent verbally agreed to pay the complainant $8,000 as a down payment, that she would use the tenant's rent payments to make complainant's mortgage payments, and complainant and respondent would split the proceeds from the sale of the property. Later, while trying to obtain a loan in order to purchase a property, complainant discovered that the respondent had missed or made late payments, thus ruining complainant's credit. Complainant stated that he was unable to obtain a loan because of this. The investigation also noted the potential violation that the respondent failed to ensure that all agreements between respondent and complainant were in writing. Possible violation is 1210-217-1M, 1210-217-1Q, 6.17. The disciplinary recommendation on this one is a diversion, a fine of $1,500, and coursework in contracts. And Investigator Deemies Wright is here for any questions.
I'm going to say I'd go hard on this. Everything about this drives me nuts. I think she took advantage of a senior. She had previous sanctions when as an MLO. I think ruining the guy's credit so he couldn't even buy later on as he was in another state. Untrustworthy, unethical, didn't act in a professional manner. There's everything. I personally, I would take her license. I would revoke her license on it. 100%. That's what I would do.
My thoughts are a little different. I thought, my notes just said, I thought the discipline, I agreed with the discipline, but there was definitely two sides to the story, because when I initially read the complainant story, I was like, there's some holes here that just don't make sense, right? And then when I read both sides, I said, okay, now the story's coming together. And when you put the two together, it does seem that she was likely approached to purchase, to put that money up initially. So I think that piece of the story wasn't really completely disclosed in the complainant's side of things, but at the same time, I think that where she totally went wrong is, number one, agreeing to it, like she probably should have just stayed away. But then number two, she did ruin his credit. And we really shouldn't, as licensees, be entering into those types of agreements anyway. But I'm giving a little bit of balance here, because I don't know that 100% of how that was presented on the complaint side was accurate. Because when you just read that alone, it doesn't quite, there's too many holes that don't add up. When you read them both, you can kind of put the story together. Either way, she was still wrong. I agree with what is listed here. And that's just kind of my opinion on that situation, but I'll let the other commissioners weigh in.
I feel like there was still like the text messages going through. I don't think he completely I think she took advantage of him just by, when you read the text messages, and he's like, you can, she's claiming that she can fix his credit. She could do all of this. And I think he was still somewhat trusting her, which I think that's where I think she was still taking advantage of him. I think it was multiple things. Yeah.
I think the big thing is that she's an employing level broker. It's not like she's an FA. And I think that level broker needs to be held to even a higher standard. And I think Bernadette's right. She should have just said no, or whoever should say no and walked away. Shouldn't have done it. But I actually thought the fine should be increased. I'm not sure, Bernadette, you're saying, revocation. I could go not revocation, but I thought the fine should go up. So I don't know, Erica Doyle, do you have any input?
Yeah, as to what Erica was saying about holes, I do, at first glance, I had a lot of questions. I was like, X, Y, and Z is not making sense to me. And so I kind of dived into this one as well. And I will say, I don't believe that there was any malintent with this one, particularly after kind of listening to both sides of those audio files on there. I will say this gal, and I'll commend her on one, she is taking full responsibility for this, and she really did try to take care of this after the fact. She did not propose this scheme. This came up at a dinner between the claimant and her father. And they proposed the sale to her and kind of pressured her into taking it on, is what I got out of this. And she ended up paying him $8,000 and then putting in a foundation and then giving it all back. I think the lengths that she went to try to repair, she knows, she's like, I shouldn't have done this. I should have put it in writing. She didn't want to do this, but she had pressure from the claimant. She had pressure from her dad, who was a licensee, to try and help this guy out. And overall, she went to great lengths to try and help this man. So I really do not feel like there was malintent on here. That being said, I do feel like the fine that is here is reasonable. I feel like the diversion is reasonable on here. But and so I would be supportive of the staff recommendation on here. I can see, Bernadette, why you would see on the surface that this was really problematic, but if you going all the way through from start to finish on how this really went down, revocation would be way too serious for what actually happened, and then what she did to try to rectify the situation. On the text messages, she tried to help get it corrected, but he wouldn't participate. He just got too angry and stopped letting her try to help him kind of fix that at a certain point. So she did try to dive in and help get that credit corrected on that end, but I had a block, and reasonably so. She admitted that. She's like, I understand why he's angry. So that's where I'm at. I would approve staff recommendations on this. I think that we're good there.
Okay.
Well,
how about you?
so on that, she asked for that 8,000 back in those text messages. She asked him to give that 8,000 back that she put in the foundation, and then she still put the property in her son's name.
Yeah, but she turned it back over to him.
Oh, no, I saw
Yeah.
that. She did. They did end up giving it back to him.
Yeah,
but
she
I just
couldn't get paid any of that back.
Yeah. I don't know. I still stick with my thought.
Autumn, do you have something?
Yeah, I think that staff recommendation is slightly light here. I felt like the fine could have been increased slightly. And also adding some additional coursework potentially on ethics.
Okay, what do you recommend for the fine?
1,500. I know that this thing it's been drawn out for a while, and just to give some conclusion, I don't know. Just counting through everything, what's the general rule of thumb? 500 for?
No, it's 2,500 per violation, but the question is, Erica think that it's okay. We have Bernadette on the opposite side.
I know.
So we're trying to figure out, so coursework and ethics, I think is great. We can add that.
I don't think revocation is appropriate based off of my review, but I think increasing the fine maybe to $2,000.
Okay, Erica, do you have any input? Is that okay?
I would be okay. I would accept that.
Okay. All right, Autumn, do you want to make a motion?
Sure, I can do that. I move to accept staff recommendations with the modification of adding ethics to coursework. And by doing so, I don't recall if we need to add 217M to the possible violations to close that loop. Looking for guidance here.
M is already on there, I believe.
I see. Oh, there it is. Yep. It's just teeny tiny and I missed it. And then increasing the fine to 2,000.
Okay. Do we have a second?
Second.
Okay. Any further discussion? All right. All those in favor?
Aye.
Aye. Any opposed?
Me.
That's okay. All right. Motion passes.
All right. Hello, commissioners. Your next item is investigative matter N. This is complaint number 2025-303 and 2025-351. The division received both complaints in February 2025 from the respective complainants, both alleging the respondent acting as property manager failed to remit rental proceeds. The investigation found that the respondent did provide the complainant of 2025-303 with their reported missing rental proceeds. The respondent currently has two property management companies, one with one operating in Texas and the other in Colorado. The respondent also operates an insurance company in Colorado. The respondent stated due to personal issues, he has relied on employees to manage both brokerages and was unable to supervise adequately. The respondent acknowledged he does not recall when the trust accounts were reconciled. The respondent provided a security deposit ledger that shows the total security deposit liabilities is $73,617.50. The respondent believes he owes around $100,000 to owners and tenants and trust funds. The investigator work papers noted the respondent commingled approximately $1,037,813.72 from the Colorado Rental Trust account to other business accounts controlled by the respondent. The respondent is the only authorized signer in the brokerage bank accounts. The respondent did not maintain a separate did not maintain separate accounts for holding security deposits. The respondent transferred trust funds on a routine basis from the Colorado Rental Trust account to his other accounts depending on the need for funds in those accounts. The Colorado Property Management Company is currently shut down. Possible violations include 12-10-2171H, 12-10-2171I, 12-10-2171M, 12-10-2171Q, 12-10-2171R, 12-10-2171W, 12-10-4041C, and rules 5.2, 5.5, 5.9, 5.10, 5.14, Rule 6.2, and Rule 6.3. And recommended discipline action includes a final agency order, public censure, revocation, a fine of $32,500 or max fines. And although not on your referral, also refer to criminal law enforcement. And myself and Investigator Marcy Rivera are here to answer any questions you may have.
Have you actually checked to see if he's not doing business in Colorado? I know it says that. Did you check to see?
Correct. His website is not, correct. His website's not coming up as active. I think it says closed or something like that.
Okay.
So there's not.
All right. Okay, any discussion on this one?
I think it's appropriate.
All right.
Yeah, we also going to see the other, because I know it said in there that there was all of other 13 complaints against him as well.
Correct. We're still working on those. So these were the first
Okay.
two that we were able to get completed and in front of the commission for your review.
So can this also be referred? I would just think that with all of this stuff that goes on here, the division of that oversees his insurance license, should that be looked at to see what's going on over there to make sure that's good? But maybe just referring it, like you said, to law enforcement, I think would also be really good.
We can definitely refer the case over to Division of Insurance as well. I don't know if there were any allegations, and we could not find any particular issues with money he was receiving from his insurance company. Not to say that there aren't issues there as well. If Division of Insurance licensing has similar rules that Division of Real Estate has, if his real estate license were to be disciplined, that may trigger a reporting requirement with Division of Insurance as well.
Okay. Yeah.
Does someone want to make a motion?
Motion to accept staff recommendation as presented.
Do we have a second?
Aye.
Okay, any further discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Your next agenda item is investigative matter O. This is complaint number 2024-1556. The complaint alleges that the complainant hired the respondent to manage the complainant's rental property in Colorado Springs, that the respondent rented her property for less than what the complainant authorized or agreed to, and also changed the lease expiration term to a length of time also not agreed to by the complainant or without the complainant's approval. Furthermore, the complainant alleges that the respondent also allowed the tenant to obtain a security deposit bond in lieu of paying an actual security deposit without obtaining the complainant's approval. Lastly, the complainant alleges that the respondent failed to make necessary repairs to the property, which led to non-payment of rent. The respondent states that the property management agreement gives her the authority to determine the rental rate, and the owner had allowed prior instances of extending lease terms and accepting lower rent. The respondent also states that all property owners were informed in April 2023 that the brokerage firm would now allow tenants the option to use a security deposit bond in lieu of paying deposit. However, the respondent failed to provide copy of this letter to the division. Additionally, the respondent failed to provide three-way reconciliation documents and appears to have failed to keep rental income in a trust account. The respondent has since closed down the property management division of her brokerage firm as of December 31st, 2024. It does appear that the respondent was keeping the owner informed of maintenance issues and needed repairs to the property. Possible violations include 12-10-2171M, 12-10-2171Q, 12-10-4041C, and rules 5.2, 5.5, 5.14, and 5.21. And recommended discipline action includes a final agency order, public censure, $5,000 fine, coursework and brokerage administration, coursework and brokerage relationships, a 3-month suspension, and a license prohibition on performing property management services. And again, Investigator Marcy Rivera and myself are here to answer any questions you may have.
Hey, Marcy,
I had a
oh, sorry, real
Go ahead.
quick, while you're, Marcy, can you double check on this website and the property management? Could you check right now? Because I think it's still active. So Bernadette, go ahead.
I
Are
just
you
had a
speaking? Okay, hold on. So she is doing sales. So
but
she's active. She's
no, the website for the company shows property management. So Bernadette, go ahead while she's looking.
I just had a question that says that she's had previous interaction with the commission, and was it completed, and were her fines paid?
I don't see that the STIP was even signed. Was the STIP signed?
That is still pending currently.
Okay.
So has she refused to sign it?
I can't speak on that. Irina might be able to speak a little bit more, but I believe the negotiation or settlement is still ongoing.
Yeah, I can tell you that it is, you know, these cases initially come to me to try to resolve. Some of them are resolved, some of them are not. If it's not resolved, because there's maybe some disputes over the facts, so it's not necessarily like a refusal, but we couldn't come to an agreement. Those cases then get referred over to the Attorney General's office for the formal process, and that's where this case is at this time. So it is a pending matter.
Okay, thanks, Penny.
Mm-hmm.
Well, and I was noticing on that stipulation that we were requiring the same courses that are recommended here on that one. So I was curious if we were just requiring the exact same ones and if she'd have completed that. But if she hasn't signed off on that step, then do we want to be doing the same courses?
I think you have to look at the individual case and what's appropriate for this one. If we get to a place where they're resolved, you know, we're not going to make somebody, like if they get consolidated down the road, we're certainly not going to make somebody take the same course twice. But we don't know what the outcome of the first complaint will be. And so you really should look at this one as to what you think the appropriate discipline is here. And then we can sort that out as we get further along.
Okay. Marcy, did you find anything?
I was checking her website too, and while there is a link for property management services on her website, there's no active listing. So it appears as if there's an element of maybe just not having the website completely updated to kind of remove all the link for related to property management, but it's currently not showing any available properties for property management.
Okay, thanks. All right, is there any other discussion on this one?
I felt ethics was missing.
It's always a good one. Okay, if there's no further discussion, does someone want to make a motion? Autumn, did you want to make a motion with that change?
Sure. I move to accept staff recommendation with the addition of adding coursework for ethics to Commission Matter O.
Do we have a second?
Second.
Okay, any further discussion?
All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
All right. Next is investigative matter P. This is audit number X 2025-104. The respondent signed a stipulation for diversion February 2025 due to deficient brokerage practices with his trust accounts from a 2024 audit. Stipulation required in part 4 quarterly audits. This was the first of the 4 audits. The respondent manages a $4.5 million property management book of business catering primarily for Boulder students, yet his trust accounts cannot be effectively audited because of the respondent's inability to produce compliant 3-0 reconciliation since at least August 2024. The respondent began restructuring the trust accounting practices in early 2025. One of the respondent's goals of the restructure is to create multiple trust accounts per client, thus involving fewer accounting transactions per trust account, helping with completing compliant 3-0 reconciliations. According to the respondent, the transition has been delayed because of internal bank procedures and accounting software requirements. Based on the current audit findings, the transition delay may be caused by difficulties with balancing a high volume of past individual transactions and staff turnover. The respondent currently has an accounting staff of only 4 individuals that he expects to have the capability to reconcile 342 trust accounts each month. Possible violations include 12-10-2171H, 12-10-2171I, 12-10-2171M, 12-10-2171M twice for 1 for violation of any commission rule, 1 for STIP violation, 12-10-2171Q unworthy and incompetent practice, Rule 5.2, Rule 5.9, Rule 5.10, Rule 5.14, Rule 5.21, and Rule 6.3B6. Recommended discipline action includes a final agency order, public censure, $20,000 fine, and 1 audit with full compliance with trust accounting and reconciliations by March 31st, 2026. And myself and Auditor Jay McLean are here to answer any questions you may have.
So have there been quarterly audits done?
So this was the first.
This is the first?
It's required by the STIP.
Okay.
And it does not appear that there has been much progress with the respondent's ability to produce compliant 3-0 reconciliations, which is why this follow-up audit is being presented to the commission today. And while the previous STIP does require for 3 more follow-up audits, there hasn't been enough. It does not appear there's been enough improvement since the last audit.
Yeah, and I just had a note, which you may have answered that, just asking historically, how has a non-compliant audit been handled, you know? Because I guess it's tough to decide. So they were already under, I have to look at the previous.
It was a stipulation for diversion.
It was diversion. That's what I thought. Okay. So then it's like, okay, so then the appropriate next step would be, because we already did diversion, so would it be FAO, right? I don't know.
Well,
Just kind of wanting to know historically how these have been handled, and then maybe that could give us some ideas on which way to go.
But were the other things done? This was the first audit. Was the previous fine paid? Was the coursework done? I couldn't tell.
I believe so.
Okay.
So I just have a thought. I mean, the previous step was February 25th. It's now October. And then it looks like we're calling for another audit by March 31st of 2026. So 5.5 months approximately.
Trying to give some reasonableness to this respondent's size of their book of business. I think the initial recommendation for 4 quarterly audits was trying to take into consideration that it was going to take some time for them to straighten out their accounting and their reconciliations. And the plan right now that this respondent has in place may be more problematic for them in trying to achieve their goal, the end goal of getting compliant reconciliations, because their goal is to create a separate rental and security deposit trust account for each one of their properties or property owners, which would result in 300 plus trust accounts. So they're having difficulty doing that now. And then, which is why, and maybe a normal or in a little bit of a different circumstance or scenario of a, let's say, a property manager who has a significantly smaller book of business, 4 quarterly audits, we may be able to see that progress over the 4 audits. In this particular one, I don't know if allowing them or giving them the ability to complete those 4 audits is going to result in compliance at the end of it. And so where we're at here, trying to give some sort of understanding that they're not going to be able to fix this overnight, but that we can't continue to kick the can down the road. That's why kind of the recommendation now is for one last audit in March of 2026. If they were to agree to this discipline and sign a final agency order and agree to a follow-up audit, if they were in non-compliance of a final agency order, then I believe the disciplinary action for that is a revocation of license.
That was my next question. So thank you for confirming that.
So Erica, in normal circumstance, when we conduct an audit and then recommend a follow-up audit, it usually starts with a stipulation for diversion. If they were to not be able to comply with the follow-up audit in that regard, then it would move into a final agency order, like the transition of this one currently.
Right. That's kind of what I was wondering. So maybe I'll just throw some things out there, some ideas, but maybe a FAO with another fine attached to it. And then, as to your point, that would give us a little bit more flexibility after that to impose more, more serious consequences.
Are you
There
looking?
there is an
the
FAO.
rec?
There's not an FAO right now.
Yeah,
There's a diversion.
No,
There is.
Are you looking at the rec? Because they updated the rec this morning. Are you looking at the new
hold on.
one?
Nope.
Okay,
So
so
you know what? Thank you for saying that, because I did print. I did get that.
yeah, so the
I
one
might
that's
have
currently has an FAO, public censure, fine of
thank you.
20,000, and 1 audit with full compliance with trust accounts and reconciliations by 3/31/26. So I think that's pretty much what you were saying. So it looks like, we might just be able to approve staff recommendation.
Yeah. Thank you for that. I was looking at the old one.
Yeah.
Where I was like, oh, we have to figure it out.
You're
Okay.
making more work for yourself. So,
Okay.
So does someone want to make a motion then?
I'll move to accept staff recommendation on matter P.
Okay, do we have a second?
Second.
Okay. All right. Any further discussion? All right. All those in favor?
Aye.
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 Any opposed? Okay, motion passes.
All right. And your last investigative matter. Investigative matter Q. This is audit number X 2024-10. In early 2024, the Boulder Attorney General issued a public statement regarding the respondent, stating that the respondent entered into a settlement agreement after a state investigation that found numerous instances of the respondent's brokerage firm illegally charging tenants for routine repairs and other services, including normal wear and tear. The settlement agreement included terms that the respondent's brokerage firm pay $1 million, which will mostly be earmarked for consumer restitution. The division opened its audit subsequent to learning of the public statement and settlement agreement. The audit included renewing the brokerage firm's move-out data both prior to and post-execution of the settlement agreement. The respondent and the brokerage firm implemented changes to their move-out and security deposit disposition processes. Possible violations include 12-10-2171M, 12-10-2171Q, 12-10-2171R, 12-10-2171W, and Rule 6.3. Recommended discipline action includes final agency order, public censure, $10,000 fine or max fines, and 2 audits, 1 per year over the next 2 years. And myself and auditor Andrew Orr are here to answer any questions you may have.
Anyone have any questions or discussion?
I'm just making sure I have because this one was
This one's
updated
new
too.
too.
So I'm just making sure I have the updated
Yeah.
information.
I don't know if this is part of the original from earlier, but I felt like ethics was missing.
It is not on the updated referral. So if that is something you would like to add, we you could do so.
I'll defer to my fellow commissioners, but I felt like that would be important.
Okay.
That would be good to add.
All right. Does someone want to make a motion?
I'll move to accept staff recommendation with the addition of coursework in ethics for matter Q.
Is there a second?
Second.
Aye.
All right. Any further discussion? All right. All those in favor?
Aye.
Aye. Any opposed? Okay, matter passes. Now next one is we're moving on to licensing matters.
All right, so licensing matter A is complaint number 2025-1662. This is a preliminary advisory opinion. On October 4th, 2024, the applicant was convicted of unclassified possession of a large capacity magazine. Applicant was sentenced to 180 days in jail, which was suspended, 60 days in-home detention, and 12 months probation, which is was ongoing until October 3rd of 2025. Additionally, the applicant has paid all fines. The applicant received a negative preliminary opinion at your last meeting, the August 2025 meeting. Since that time, the applicant paid their fine, provided a new letter of explanation, and then also their probation ended on the 3rd. There's no recommendation, and Investigator Quinton is here to answer any questions you might have.
There still wasn't a personal explanation as to what was going on with all of the guns and magazines. There was no, unless I missed it, I didn't see anything addressing that. So I still kind of have a problem with this one.
I was with you on that.
Looking at my notes, I was a little, I was on both sides of this. One thing that in reading his response, although it did lack some things, like it lacked recommendations and things like that. But in reading his response, one thing that I thought, he was, pretty young, although this wasn't that long ago. He's pretty young when it happened, but he seemed to be in a much better place. And sometimes I think, when you're young like that and you make really bad decisions, allowing him a profession might put him on the right track. Like he seemed to have a lot of pride and that he was able to pass a test, and he just seems like he really is feeling accomplished. And that can, for some people, be in a positive way, a very life-changing thing, just to have that chance. Because of, there's a lot of different things. He just got off probation, so it's a little bit of a risk, right? But I noted that I would be open to a positive opinion, because he really just seemed to have found himself. He's acknowledging all the things that he did. He was a younger person when this stuff happened, and I think that based on his statement, he said he has overcome a lot of those personal challenges, and I just think that maybe he just needs a chance. So that's my thoughts. I was, at first glance, I thought, oh goodness, but when I really dug into it, I had a different perspective, and I thought, man, this might be something that could really put this individual on a positive path. So that's just my opinion.
Erica, I felt the same way, and he's going to have tutelage and work under a supervising broker. He's fulfilled all of his obligations and his requirements, so I would move towards a positive.
I agree with all of that.
I put that I would give him a second chance I know when he wrote this, he was barely going to be getting off of probation. It was going to end, like, I think it was like on October 3rd. So as long as he finished that, I would give it a positive recommendation. I did also write, he never took any responsibility and didn't say anything about the magazine or the stolen tags on the car as well. But
I thought he
Right.
covered that in his letter, but
No, I don't think he did. That's
He didn't
yeah.
get specific, but he did talk about how he made some really poor decisions. I felt he took accountability just for, and to be honest, the sentiment of his response was that there's probably other stuff that we don't even know about, but he took responsibility for some of the things that he's done. And although he didn't, specify details of why he had the magazine and et cetera, he just said, mentally he was in the space. It looked like he's maybe getting some help there. And his work history also wasn't great. And I remember seeing that. But I don't know, something in me just felt like this, maybe he just needed a chance. But that's just my thought.
We're missing recommendation letters. I just, there wasn't anything really to back this stuff up. So
maybe he needs some stability with with it. But I do have that written down too on here, that he didn't have I didn't see a broker that he could go under. But I figured he was looking.
This is a preliminary opinion right now.
Mm-hmm.
So
Right, they don't have to have an employing broker when they apply for that.
all right. Does someone want to make a motion?
Yes, sorry, I'm just trying to remember how to do this motion over here.
You just motion for a positive or negative.
Yeah, I motion for a positive opinion on the, I motion for a positive opinion.
Okay, any further
Or A.
discussion? Oh, sorry, I need a second.
Second.
I'll second. Okay.
Okay, any further discussion? All right, all those in favor?
Aye.
Any opposed? Aye. Motion passes.
All right, licensing matter B is complaint number 2025-1269. This is an application. On June 24th, 2021, the applicant was convicted of a Class 2 misdemeanor, invasion of privacy. The applicant was sentenced to 1 year of probation and a fine of $1,965.50. The applicant has completed all terms of probation and has paid the fine in full. The case is closed. There's no recommendation, and investigator Quinton is here to answer any questions you may have.
Okay, is there any discussion?
When I saw this, my notes just, kind of state this happened a long time ago. He doesn't have any pending, like issues related to this, no outstanding fines, no probation or anything like that. So, my
And a
thought,
very positive letter.
yeah. And so my notes were to fully approve the application.
Any other discussion, or does someone want to make a motion?
Mine was similar, conviction disclosed, no balance, probation complete, letters of recommendation, including managing brokers letters. I have a positive recommendation noted.
I do too. Took full responsibility, paid all fines, had letters of recommendation. I said I'd give him a second chance. I think he's done a lot and feels remorse for what he did. So,
okay, does someone want to make a motion?
All right, motion to approve the application for licensure.
I need a second.
I'll second.
Okay, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, license is approved.
All right, licensing matter C is complaint number 2025-1560. This is an application. The applicant has had a dental license issued by the Division of Professions and Occupations since April 30th of 1997. The applicant has 4 stipulated agreements in a letter of admonition between January 6, 2003 and April 11th, 2024 related to this dental license. The applicant reports that he has closed his dental practice and wishes to pursue a Colorado broker license. There's no recommendations, and the agenda has Tabitha Quintana as the investigator. It's actually David Levy. He is not here right now, so I can try and answer any questions you may have.
Okay, any discussion?
Oh yeah. My notes, I was really concerned with the number of disciplinary actions that had taken place. Although it was in a different profession, and there was one most recently in 2024. So my opinion is there just appears to be a pattern of the inability to properly be regulated, which gives me a little bit of pause, if I'm honest. So due to multiple incidents, which I believe it's a total of 5, because it was 4 stipulations and then 1 letter, it just, gives me pause, because if it appears that perhaps this person had to leave that profession because, they just, every time you turn around, there was some kind of there was some sort of disciplinary action. He had some very positive letters, some good character witnesses, but in terms of regulation, if it was 1 incident, 2 incidents, I think that could be understandable. But when you have so many, it's just concerning, going from one regulated industry to the next. So my opinion was a denial, but everyone will weigh in on it.
Well, Erica, I'm reading his letter dated September 14th, and according to this, his dental license continues to be active to this day, in addition to a federal DEA license.
This, well, he may have a license, but he closed his practice, yeah.
So, he's still continuing education requirements to uphold that dental license. Just want to make sure that we all understood the facts.
Yeah, I think I was, you're correct. I was actually, should have referred to the practice, which is closed.
Yeah, so I don't think he closed his practice out of lack of licensure, just closing his practice after 30 plus years of being in that industry, maybe a little burned out on it. But I also heed your concerns about multiple issues, especially one being as recent as 2024, but was curious to get the thoughts of my fellow commissioners.
Anyone else?
I'm just going back in to take a look at that. On the discipline, were some of these combined into one? Because I hadn't written it down as like 5 different disciplines.
So if you look at
So,
and then I'm looking at what the discipline is as well.
Well, 2024 was the closest one.
Right.
And then before that was 2016.
And this document that I'm looking at is only going over, it might be just be the explanation.
It appears there are 5 separate instances, yes.
Okay, any more discussion, or is someone ready to make a motion?
I mean, are the rest of you leaning towards an approval, or is anyone on my island of concern just with the number of instances? And it sounds like it's over a very lengthy career, but you just kind of wonder, obviously you can have a career span that same amount of time with no incidents, maybe 1 or 2 incidents, but to have like 5 is a lot to me.
But he's in compliance with his licensure from the dental community. So I don't know if we necessarily have a leg to stand on to deny approval.
His last stipulation was in 2024, so I think that would give us a leg to stand on, plus the repetitive nature of what's going on. Does someone want to make a motion?
I'm just briefly I'm going back into the
I'm looking at it too.
file just to make sure I'm not like missing anything notable, but he had a stipulation, and let's see. There was discipline in 2008. (2010).
This doesn't tell us what the last one. Well, maybe it is. I didn't write down what it was in 24. But let me see.
The other thing is, I don't know if everyone had this, but there was also no in my file that I reviewed, there was no employing broker letter. Did we?
Yeah, there
miss that,
was.
or-
There was, yeah.
Okay, mine just says placeholder. I don't know. Maybe it's because I looked at this a while ago, so I didn't know if that was added later or something.
It was, yeah, that was
Okay.
provided late last week.
Okay, yeah, I didn't have that.
We have that was disclosed on the application. There was a managing broker's letter, letters of recommendation.
I mean, is it possible, and I'm just splitting hairs here, but giving a positive opinion with restriction?
It's an application.
Yeah.
So
And I may be the only one on my island. So it's really, I'm just trying to get a feel for what everyone else feels. I mean, I've kind of stated my thoughts and opinion, but I don't know. It's
Well-
unclear. It seems like Autumn is for the approval just based on the conversation, but I think everyone just weigh in on what you think, and then we'll go from there.
I mean, I have some concerns as well, but I don't know if there's enough to limit an approval.
Well, and you wonder, would the issues that we've got in front of us there impact their ability to practice real estate? And so I'm looking at the specific issues as well at hand.
Yeah, that's a good approach.
we have a stipulation in the last 3 years. So at that point, it's considered ripe. So
Okay.
it can be denied for that, but we could also look, the next step has to do with rehabilitation and performing duties. So it just depends on what you think currently.
Commissioner, Madam Chair, if I may, this one's slightly different. You're doing a great job applying criminal conviction requirements, but this is not a criminal conviction. So you can use it as a model, but you're not required to, because this is
Okay.
licensing issues, not so much criminal.
Okay.
No
All
issues
right.
with criminal.
Thank you. Okay, so you guys understand that we don't have to do the criminal conviction because it wasn't criminal conviction, it was a stipulation. So you can say whether you want a positive, whether approval or denial of the application.
And right now we have one that said denial based, and that was more specifically based on the number of incidents, which is myself. So maybe if the other commissioners can kind of weigh in on what you're leaning towards, and then we can just tally it up and make a motion.
I think based on what the issues were, they don't necessarily apply to a lot of carryover into what we are doing. I think that he needs to be very cognizant of what we do and look at all of the rules and act accordingly. But I would go ahead and give him a chance at doing this.
And I would agree.
Positive.
Okay, Bernadette, you have input?
I'll agree with that.
Okay, does someone want to make a motion?
Motion to approve. Licensure.
Okay, do we have a second?
I'll second.
All right, any further discussion? All those in favor?
Aye.
Aye.
Aye,
Any
and I'll agree.
opposed?
I'll agree with you guys.
Okay, any opposed? No? Okay, application is approved. Okay. Then we're moving on to ESP matters with Penny.
Yes. So the first one I have for you guys is case number 2025-94.
Penny, can you turn the volume up? Or maybe, I don't know if it's just, or not.
I'm having a hard time hearing her too.
Let me see what I can do.
It just sounds a little muffled.
Mm-hmm.
I think I had things, is that a little bit better?
No.
No?
Not really, but
I'm getting as close to my computer as I can, and I have the volume all the way up.
Okay, we'll be quiet.
So sorry. I'll try to speak loud.
Okay.
So the first is a STIP violation case. Stipulation was signed back in April. It was for a continuing education audit. They did pay their fine. They paid it late, but they did pay their fine. And now we just can't get them to complete their coursework. And so we are recommending moving forward with a STIP violation case, seeking a final agency order, a fine of $2,500, a 30-day suspension to continue until compliance.
Okay, is there any discussion on this one? If not, does someone want to make a motion?
I motion to approve staff recommendation.
Okay, who said that? Erica or Autumn? Erica.
I started to, and then I recanted.
Okay, Erica, Autumn, do you want a second?
I'll second.
Okay, all right. Any further discussion? All right, all in favor?
Aye.
Aye. Any opposed? Motion passes.
Okay, next one, same issue. Signed a stipulation back in March, continuing education audit, did pay the fine, and the coursework remains outstanding. And so looking for the same recommendation, a STIP violation, a final agency order, a fine of $2,500, and a 30-day suspension to continue until compliant.
All right, any discussion, or would someone like to make a motion?
I motion to approve staff recommendation.
Do we have a second?
I'll second.
Okay, any discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Okay, motion carries.
I am going to pull matter C. It appears as though we have compliance, but if there turns out to be an issue with that, then we'll revisit it at our next meeting. But right now, we're going to go ahead and pull that one.
Okay.
So the next one is matter D. And this is a stipulation that was signed back in March. It was a violation that involved criminal conviction and failure to notify. There was a fine that was due. Excuse me, the fine has not been paid. He would have a probationary license that I can't necessarily say he hasn't complied with because he's currently inactive. And so that would be something that if he was active, the probationary license would need to be in place. But right now, this is basically for the failure to pay the fine on the stipulation that he agreed to. So again, seeking a violation of the order, a final agency order, public censure, revocation, and a $2,500 fine. And the reason this one is escalated over the others is because the original order that he signed was a final agency order, and it says on there if you fail to comply with it that you revocation is the next step.
Okay, any discussion?
No, I just appreciate that explanation because that was actually my question, was why not like a suspension or something? So thank you for that.
Okay, would someone like to make a motion?
Motion to accept staff recommendation.
All right, second, anyone?
I'll second.
All right, any discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Motion passes.
And our last one is another violation for a continuing education audit. They signed an agreement back in June, accepting a fine and makeup coursework. They have paid the fine. They have not done the coursework, despite our efforts to get them to. They remain active and non-compliant. So again, moving forward with a violation of the order, a $2,500 fine, final agency order, and a 30-day suspension to continue until compliant.
All right, any discussion, or would someone like to make a motion?
I'll move to accept staff recommendation.
Okay, do we have a second?
Second.
Any discussion? All right, all those in favor?
Aye.
Aye. Any opposed? All right, motion passes. Now, I think Marcia has redone what we were working on earlier. Did everyone get that in their inbox?
Yep, gotta review it, but yeah.
This is, sorry. I got the CREG minutes from the August meeting.
No, not that.
So I am locked out of my Colorado account. So if it can be forwarded to my
I
other
sent it to your Gmail account, your personal Gmail account.
I'm not seeing it, guys. I apologize for the sheer amount of email issues that I have been experiencing, but I am not seeing it.
Give me a minute and I'll send you the link again.
Okay, thank you.
Okay. All right, so the one that we're looking at is Commission Position Statement 31. And Marcia, do you want to go over this, or do you want me to say a couple things about what the changes are? Or do you want to do it?
So I deleted the one reference to the sentence about an ER needs to anticipate how to perform their supervision duties. And then the other changes I highlighted in red because Google's a little different.
Okay, so where's...
I'm not seeing it either. Can you resend that to me? I'm looking on both of the email,
Okay.
Oh, but send it to my Gmail, or send it to the Gmail one because my other one will block it.
Weren't we going to take out the sentence after number 3, the one that said, in determining which solutions may be appropriate, the employing broker needs to assess the abilities and experience of the designated broker and anticipate any possible issues that may arise? I had in my notes that we were taking that out as well. Is that not correct?
I thought you wanted it removed from the rule, but the position statements are there to provide guidance.
Okay, I thought someone said they wanted it out because, okay, I'm not sure who said they wanted it out, but I had it down to remove it.
Yeah, that was one Erica had pointed out, but I need to look at
Yeah.
the reference.
I wrote, yeah, it should be modified to match.
Well, the one that got removed is the second sentence. We had the one after F, we had kept the first sentence, took the second sentence out. And then the one after 3, I thought we were removing that sentence. I thought Erica said remove that one. I don't
Can
know.
we pull it up? Can we pull it up on the screen or no?
Give me a minute.
Oh, but now we have a whole bunch of verbiage after, at the very end. Now, what is this?
Cool. And I finally got your email. So thank you.
Okay, so what I'm saying based on my notes, the sentence that says confidential information may be shared with the employing broker if the designated broker obtains the client's informed written consent. Commission Rule 6.7 sets forth the requirement for informed consent. Without informed consent of the client.
Hold on, where are you? Where are you? What section?
So this is I was trying to see if I could get a
page 2.
Page 2.
Towards the end.
Yeah. So that's the only thing, it's kind of hard to reference, but it starts with, the paragraph starts with confidential.
Oh, after F. After F?
Yes, yes.
Okay.
And
Okay.
so, and then it says, without informed consent of the client, potential solutions available to the employing broker include but are not limited to. So on that one, I'm verifying that that sentence was removed.
Yep.
And then I noted under number 3.
Yeah, I thought that was coming out.
Let's see. Yes, under number 3, I had notes that the part that says, in determining which solutions may be appropriate, the employing broker needs to assess the abilities and experience of the designated broker and anticipate any possible issues that may arise. I had notes that that was being struck through that whole thing.
Number 3?
No, after
no,
number,
the
that
one
sentence
right after number 3.
But actually, in looking at it, it doesn't seem like it's that bad. I don't know why I'm looking at it now. Why were we taking it out?
It's in between number 3 and conflicts of interest.
But wouldn't you want to evaluate your broker's abilities? Like if they've been licensed for 2 days and they are dealing with something that has water rights and they have no experience with water rights, wouldn't you as the employing broker want to be able to assess that?
Yeah, I agree. I'm not sure why we were taking it out. Does someone remember why we were taking it? Because it does seem to make sense.
Yeah, there were, let me get to my page here. There were 2 sections that it was in at one point. It seemed like we were having to do it absent client's informed consent.
Well, that was the first
That-
one.
That was removed.
Right.
So it was in here like twice. So
Okay,
this
but
one
this-
does not say absent client's consent. It's a little more reasonable. It's just hard to, I don't want this to be the expectation that it comes back and we're like, and you were supposed to have known that was going to happen. And we're like,
Well,
yeah.
I think your issue reading it again, I think it wasn't so much the entire
was the
paragraph. It was
anticipate any.
saying that the designated broker would have to anticipate any possible issues that arise. So I think your issue is more with the language of the broker has to anticipate any issue. And I think the intent was to soften that a little bit and maybe not use the language of any possible issue.
Okay, is there a way to soften it? And try to anticipate? I don't,
Employing broker should assess the abilities and experience of the designated broker and anticipate potential issues and try to anticipate.
I like what you said, and anticipate, potential. Oh, I can see Marcia typing.
Yep, it's easy.
It's real time.
Maybe put and try to anticipate. That way it's not like, it's just giving us actionable versus.
so we're going to say try to anticipate
potential issues that may arise.
potential. Okay.
And so
Okay.
the last section, all I did was moved. There was a statement that just said no confidential information about the opposing broker's client can be shared with the employing broker. That matches the language in the proposed rule change. So I just kind of moved that up so that it's not an independent sentence. And then it gives them guidance on how to kind of navigate that issue should it arise. But keep in mind, these are position statements. They don't carry the force of a regulation. This is for you guys to provide them with some guidance. Some of the position statements include best practices, but we don't ever say that somebody violated a position statement. This is to give them, God forbid, they are unable to come up with, how do I manage this? This gives them an idea. This is also the same language that I will be taking out of, that's the second sentence in 6.17E.
But we took it out of that. I thought we took it out of 6.17E because people didn't like it, and now it's in here.
So with it being in 6.17E, if they don't do this, you could discipline them for it. With it being in a position statement, it just offers them guidance on how to deal with that situation. It's not a requirement.
I guess I'm confused. I thought we took that sentence out of E, so it's not in there.
Yeah.
I have
So
it.
it will not be in that rule when I file it.
Okay. But now
With
we have it
being in the
here.
rule, that makes it a requirement for them. With it being in a position statement, this offers them guidance. It's not a requirement. So if they can't figure it out on their own, they can at least look at the position statement and get a suggestion on how to deal with the situation.
Yeah, it kind of, that red section puts us back to where we were with the rule in a couple of the areas of this, because number one, it's back to an experienced broker within the brokerage firm, which may not be possible, versus just an experienced broker. And I mean, obviously, ideally within the brokerage firm, but that's not always going to be the case. And then the second part is, if it's not possible to delegate supervision to another experienced and competent broker within the brokerage firm, then representation of the opposing broker's client should be referred to a broker who isn't licensed with the same firm, which is now, to me, saying we've gone back to that scenario where you're having to give up that relationship versus maybe just getting the supervision for that one issue. Does that make sense?
I can delete this and you don't provide them with any guidance on how to navigate the situation. It's fine with me. I am more than happy to strike the language after the no confidential information about the opposing broker's clients can be shared with the employing broker.
I think it's helpful to have that in there. And in fact, I'd probably add, and this is just my opinion, in addition to a broker who's not licensed with the same brokerage firm and or a real estate attorney.
I mean, help me understand. This doesn't carry weight of rulemaking. This is a guidance beacon for when this situation occurs and people need help in understanding what to do or what are their options legally.
Why would we take it out of a rule, but we put it in a commission position statement? I know
Because
you're saying it's different, but
well, and
it's
I
still
think there's
there.
going to be a lot of questions when, in the off chance that this arises, like all the conditions have to be right. And let's say that you have questions, you can't get a hold of the commission or ask those questions directly, and you're reaching out to real estate attorneys, you're talking to other brokers, and it really hasn't been set as a precedent because of this new rule. I think it would be helpful to have some kind of beacon to help you flowchart this and figure a way out.
Well, kind of back to my original concern with the language. If this is being used as guidance, and I don't know that the industry completely understands this isn't a rule. Like, they will really use this as guidance. And so when it says that the employing broker would need to delegate this to another broker within the brokerage firm, for one, that to me is problematic.
It says may delegate, not must.
Right, but then it says within the brokerage firm, and I thought one of the things we talked about is just leaving it at experienced broker, because if you are a brokerage firm of 3, how are you, even let's say 2, how are you going to delegate that to another broker within your firm?
So then that may not be an option. Then that may be when you have to refer them to somebody else or an attorney.
And then delegation must be ready in writing before receives.
Yeah, there is a contingency where should delegation of supervision not be available.
But then it says, so that's a supervision, but then later it says, and I'm more of a literal, like I'm reading this literally, if it is not possible to delegate supervision to another experienced, competent broker within the firm, then representation of the opposing broker's client should be. So now we've moved from supervision to representation now to be referred outside the firm. And I guess I'm not understanding why it has to be a broker within the same firm if you're a small, because again, I have the small brokerage in mind here. So if they don't have an option, this is basically saying, well, if you don't have another broker in your firm, then you're just gonna have to refer that transaction out, versus this initially it was saying supervision is what you're delegating. You're not delegating the whole file necessarily. You're delegating the supervision with informed consent. Now this is especially this last sentence is saying, sorry, well, if you can't delegate it to someone within your firm, then you're going to have to just, let someone else take that transaction. And so it's not allowing that supervision.
But you've got a conflict because you're the employing broker representing a client on the other side of that transaction. So if that designated broker is not competent to manage the different aspects of that transaction, you can't supervise them. They can't give you confidential information.
Right. But they could be supervised by another broker, right? Or am I misunderstanding the whole thing?
So it's if there's another broker in the firm that's capable of supervising them.
But only in the firm, so it couldn't extend to.
That's like hanging your license under multiple brokers, which you can't do.
Okay.
So if they don't know what they're doing, which they should be doing this anyhow, if they don't know what they're doing and their supervisor can't supervise them, it should be getting referred to somebody who does know what they're doing, rather than, becoming one of your respondents in one of your meetings, test cases where they have winged it and done a bad job. But this is just guidance.
Do we mention the attorney?
Some options. I can add the attorney aspect onto the last sentence, like Autumn recommended.
I mean, it's not, it's, I'm going to say it's not ideal, but at this point, I don't know. It's just like, this is a really challenging thing to navigate. So,
Well, and can I ask a question? I mean, the cat's out of the bag. We're having to move forward regardless, right? As we continue to learn and grow things into next year, this is a living, breathing document, is it not? Like if we start to see a reoccurring theme, we have the opportunity to come back and maybe define or limit or even soften language as needed. Is that accurate, Marcia?
Yes, these are a lot easier to change.
Okay.
Rules are not that difficult to change either. It's statutes that are really difficult to change. But if this turns out to be something that is very problematic for the industry and they can't navigate that one situation, this is something that you guys can revisit and make modifications to.
Okay.
So I did add at the end of the last sentence, or a licensed attorney. They have competency requirements for that license as well. So if they don't know what they're doing, they shouldn't be accepting business. So like if they represent traffic cases, they shouldn't decide to help you with a broker supervision case.
okay. So let me just give you a real life scenario to make sure I'm understanding and I'm comprehending the clause properly. Okay, so there's a conflict because employing broker A and B and designated broker are on the same transaction. Designated broker B has an item that they need supervision on, but they can't come to designated broker, to employing broker A because they're on the other side. So now designated broker B can go to designated broker C in the office for guidance or an attorney for guidance, but it's still part of this active transaction.
Yes.
Am I understanding that right? Okay.
Mhm.
But in that situation, there has to be informed consent in writing in that scenario.
The informed consent comes into play if they're going to be sharing confidential information.
Okay.
But if there was just employing broker A and B, and there's not a third broker to do that, you're saying that if there's not an attorney involved, they've got to kick that out to a different agency, basically.
Well, that is a possible solution.
Because they can't have informed consent in that instance. I know that's what that's how I understood you to say earlier, that in that instance, the buyer, let's say buyer and seller on the opposite sides could not consent to that one piece of information being.
Yeah, because there's a conflict with the employing broker.
Okay.
I would also suggest thinking of as your designated broker on the opposite side of the transaction of the employing broker is like a veteran. They've been in the industry for 20 years. They know what they're doing. They don't need guidance from their employing broker. I don't necessarily think that you're going to have kind of that come up with this issue.
Right. But if we do, we revisit this potentially. If we find that it's problematic or we just, get too many.
See the firm attorney working in this. You have a firm attorney, and then so you have each side, and you're like, okay, I'm going to call the attorney for a question, and then this person's calling the firm attorney for a question. Is that how you're seeing that work? Or like if you're just like, we've just got to bring an attorney in to deal with this?
It's one possible suggestion. Like if you need some guidance on a complex issue, I could see calling the firm's attorney for guidance.
And
because you've got an employing broker that's conflicted out due to their representation of one of the parties.
And this is just another, I know this doesn't apply to everyone, but would an example be you have your firm attorney that may be handling the managing broker, but then you have, for those that are members, an association that has that as a benefit where that other broker could maybe reach out to that attorney, or maybe they just have their own attorney. Is that kind of a way that could work?
Hopefully you're reaching out to your own attorney.
I'm saying the employing broker, because then you have the same, the employing broker has the firm attorney, which shouldn't be referred to
anybody.
The other broker, right? On the other end is what I'm saying. You need two different attorneys in that instance.
if you've got the employing broker and the employing broker is conferring with the firm's attorney, and you've got the designated broker on the other side with the client that frankly cannot they can't give you informed consent at that point due to the conflict, and there's a complex issue, then that's probably when you're going to have to look at a separate attorney to help counsel that client on that issue.
Okay.
Which, like, if it's that complex, they probably should be engaging an attorney anyhow.
Right.
They have their own type of malpractice insurance that covers those sorts of issues.
Okay. Well, I mean, I think at this point we've exhausted this whole topic. So, you know, as I said in the meeting, we just got to rip the Band-Aid off and just see what happens. But I think this is the closest we're getting to make everybody happy.
So are you ready
What does
to
that mean?
Well, so are you ready to adopt the change language that you guys are seeing here? And then we can go ahead and get both of these position statements finalized and out there for the industry so that they've at least got this guidance in place as you start to move forward with the forms will go into play January 1st. That's their effective date. And then rulemaking will happen in December. And typically with the timeline with the rulemaking, if you adopt rules at your December meeting, they're probably going to go into effect mid-January. That's just how the timing usually works.
Okay. Okay. Well, I'm prepared to adopt this with the correct. Did we correct that one piece? Yeah, I didn't see what it ended up being, but
is everybody ready to move forward or not?
And try to anticipate potential issues. Okay. I'm ready to move forward. I know I gave a lot of pushback on that last like section, but I'm ready to proceed.
Okay, everybody else? No one's saying anything.
I'm saying yes. Do we need a motion this?
Well, I'm just curious. No point in doing a motion if we're not all ready. That's why I was just asking if everyone was ready to move forward.
Yeah.
One
Yes.
yes, one yes, and two no comment.
Yeah.
I said yes. So.
Okay, any other discussion? Okay, then someone want to make a motion?
I move to adopt language as modified in today's meeting for policy matters. Geez, I don't have the list in front of me.
No, for CP 31.
Thank you. For CP 31, management of confidential client information.
Did we already do CP 22?
You did.
Yeah.
Okay. All right.
Don't add to your workload.
That's been
quantified. We're good.
Okay.
2 minutes.
Okay, Autumn did the first. Anybody have a second?
I'll second.
Who said that?
Bernadette.
Okay, sorry, I'm writing stuff down. Okay, any further discussion? All right, all those in favor of approving CP 31?
Aye.
Aye.
Any opposed? Okay, I guess that's it. Motion passes. Oh my gosh.
We did it, guys.
Commissioners.
Oh my gosh. We
Have
all
a good
did.
evening.
Just
We
a
all
quick
need a drink
question.
now. Okay.
We don't anticipate all our meetings to be like this, do we? The
I
last two have been like
sincerely hope not.
8 hour, 9, like they're forever. Oh my goodness.
Okay, thank you, everybody.
Everybody.
Motion to adjourn, right? Do we need to make a motion?
Yeah. That's what I
Oh,
was gonna
sure.
say.
Motion to
We're just so
adjourn.
ready to get off of this.
Do we need a
call.
second?
At 4:59.
Okay, all those in favor?
Aye.
Aye.
Okay, thank you.
Thank you, everybody. Enjoy your
Aye.
evening.